Looks like we're set to go. This is the Board of Oil, Gas, and Mining hearing taking place on Wednesday, February 27th. And the first item on our docket is docket number 2018-013, cause number S0030034, in the matter of reclamation of the LUCIN VARISCITE mine. This matter has been continued to this meeting, but has been resolved and dismissed. As I recall, without prejudice. Is that correct, Steve?
Yes, without prejudice.
Okay. Is there anything that you would like to say into the record?
No, I think maybe, if anything, the record should reflect that Emma Whitaker and the division and worked closely with the BLM. And it's not fully resolved, but we have full bonding now, and we have a permit that's signed. And so based on a reclamation contract that's signed, as well as a BLM right-of-way application. So great progress, and just report that to the board. But I think we filed a motion to have the matter dismissed without prejudice.
Thank you, Steve. Mr. Alder, sorry. We're going to go a little bit out of order here for a moment. Item number 5, or agenda item number 5, docket number 2019-006, cause number 139-163. In the matter of the request for agency action of Altamont Energy Operating LLC, this matter has been continued to the board's regularly scheduled meeting on March 27th, 2019. That matter will not be heard today. Now, we'll step back to docket item number 2, or agenda item number 2, docket number 2010026, cause number C/015/0032, the matter of the request for agency action of Genwell Resources, Inc. Essentially, it's the request for the board review of the division order D010A requiring bonding for the perpetual treatment of mine water discharge at the Crandall Canyon Mine in Emery County. Petitioners requesting release of the water treatment bond. I guess we would start this discussion with Ms. DeGroux, if you'd like to.
Yes, Mr. Chairman, thank you. I'm Denise DeGroux with the law firm of Snell and Wilmer, and I'm here on behalf of Genwell Resources, and we have filed a petition which the division has kindly joined in to release the $720,000 water treatment operations bond that's been on file since about 2012 in this matter. The operator filed the bond to treat water that was discharging from the Crandall Canyon Mine. Per the board's order, the operator has provided a hydrologic report twice each year since 2012, and the board and the division have closely monitored the water quality discharging from the Crandall Canyon Mine. Over the past 20 months, we've shown compliance with the focus actually of the concern of the board was total iron concentrations and whether those total iron concentrations would meet water quality standards. And for the last 20 months, the operator has shown compliance with that water quality standard. So based on the board's 2012 order, once the operator had shown 6 months of compliance, they would qualify for a bond release or to petition the board for a bond release. And so that's what we're doing here today. The division and Genwell have joined in submitting this matter to the board, and we've also cooperated on the form of the board order and the proposed board order. So I think we're in agreement on this matter, and we've on January 10th submitted the last hydrologic report to this board, and based on the findings of that report, we would request that the bond be released and that the board sign the proposed order in the form that we've submitted it.
Mr. Alder?
Thank you, Mr. Hanson. The division joined in that request, and we're grateful to see that we're in this position. It was a long time ago, and so the division did take the opportunity to file a memorandum, not in opposition at all, but mostly just to remind everybody how hard this was. And I want you to know that that memo was not intended in any way to be critical of the board, but rather to just point out that these are hard problems. It was hard, and there were competing experts about how long and what the nature of this discharge was and what would happen in the future. There was a lot of discussion about what the law is relative to protecting these waters and particularly providing bonding. And it was determined by the board at that time that if we needed to have a longer term bond, that we would need to have rules. So I just appreciate the opportunity to file that memo, and that's the purpose. It's just to remind the board that there's some unfinished business. This is really one of the most difficult areas of regulation of mining that there is, because of course everybody cares about the water, and yet it's so hard to predict how to deal with it, and the tools are just not quite there in our opinion. I think the board determined that the tools weren't there either in this matter, and so kudos to Jen Wall for sticking in there and making this work, and for cleaning up this water, and we look forward to having the site fully reclaimed. But that's the purpose of the memo, and I apologize if it appeared to be critical of the board. It wasn't intended that way.
Thank you, Mr. Alder. Board, do we have any questions or discussions that you would like to have with the councils? I think that Mr. Kendall and I, other than Mr. Gill, who's not here at this moment, we're the only surviving members of the board that were here at the time, and do remember it being a very interesting and difficult issue to address. And I think at this point we would need to explore further how we will deal with such instances in the future through probably some rulemaking. But obviously I'm not suggesting we start that today.
Nor are we.
Well, if there's no further comment or questions, I believe there's a need for a motion to be made that we accept the petitioner's request for the release of the water treatment bond.
So moved.
Second. All those in favor say aye.
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 Any opposed? Let the record show that that was unanimously approved by the board.
Thank you.
Thank you for your efforts.
Thank you, and thanks to the board for their patience and for maintaining continuing jurisdiction of this matter. And we think it's your vigilance and not just good luck, and that made us, prevail. Thank you.
Thank you, Mr. Gu. Next item on the agenda involves KGH Operating Company. Do you guys need a few minutes to get set up?
No, we're all set, Mr. Chairman. On this matter, the KGH matter.
I'm sorry?
Mr. Hanson, if I might, I think the KGH matter, I don't know if the board intends to read it into the record, but that's just a report which has been submitted, and Mr. McDonald is here for this client, but I think the understanding of the division was that there would be no action taken. The board would just accept the written report, and I don't know if that's if you need a motion to do that or not, but.
Well, that's a good question. I guess I don't know the answer.
Mr. Chairman, Fred McDonald on behalf of Whiting Oil and KGH. The board's order back a year ago indicated that they wanted a report on the well and how correlative rights would be protected. And that report was submitted on February 10th under confidentiality to the board. And it is KGH and Whiting's position that that report should satisfy the board's order and that no additional hearing would be required at this point.
The division, I assume, agrees.
I think the division believes that if the board has questions, that it should be arranged at a time where the presentation can be made in a confidential manner, and it wouldn't be appropriate today. Yeah.
Well, I think what I'm hearing is that you do not want us to read this into, okay. Well, we will then, I guess there's nothing more for the board for us to do. Certainly. Kendall?
I'd just like to, I think, commend KGH. I thought the report was very thorough, and I was pleased with it, and wish that some others would take a lesson from that if it wasn't confidential. But yeah, I'd like to commend them, and if you could pass that on to them.
I will, Mr. Kendall.
Thank you for your patience. I think that we will accept the discussion that has been brought forth, and we will move on to the next matter at this time. Looks like the next agenda item on our schedule today is docket number 2019005, cause number 187-12, the matter of the request for agency action of Middle Fork Energy Uinta LLC for an order modifying the board's order entered in cause number 187-09 and suspending Utah Administrative Code Rules R649-3-2, paren 1, and I'm not going to read the rest. I think at this time we will take appearance of counsels.
Fred McDonald of McDonald and Miller on behalf of the petitioner Middle Fork.
Thomas Kessinger, Assistant Attorney General for the Division of Oil, Gas, and Mining.
And I assume you have witnesses you'd like to swear in at this time?
I do, Mr. Hanson. With me today are Mr. Worth Carlin, the Vice President of Land, Mr. Chris Castle, who's the Chief Geologist, and Mr. Rob Zabek, Vice President of Development. And I'd ask to be sworn in at this time.
Okay, can we proceed with that?
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
Thank you, Mr. Chairman. The resumes of all three witnesses were submitted collectively as Exhibit A in this matter. If separately asked, each would verify the contents of their resumes are true and correct. Mr. Carlin will be testifying as a fact witness only. However, neither Mr. Castle nor Mr. Zabek have testified before the board, so we will qualify them respectively as experts in geology and petroleum engineering at the commencement of their testimony. I'd like to confirm that the board received the substitute Exhibit F and the supplement to Exhibit Z on Monday.
Yes, we did. Thank you.
Okay, thank you. And also, Mr. Chairman, I want to confirm that it's acceptable to move for our admission of all of our exhibits at the end of my presentation in chief.
That would be preferable.
Thank you. Ladies and gentlemen of the board, Middle Fork is before you today seeking partial modification of a 2006 board order entered in cause number 187-09, which authorized a 20-acre well density for production from the Wasatch and Mesa Verde formations within Section 16 of Township 9 South, Range 22 East in Uena County, among other lands. Specifically, Middle Fork is requesting the board to first separate out the upper Wasatch from the Mesa Verde and upper Mancos groups under that existing order, and to modify the interwell setbacks to more closely align with the fracture orientation and drainage ellipticals. Neither the well density, 20 acres or up to 32 wells per section, nor the sectional boundary setbacks are being modified. Because a single well pad and an S-curve drilling will be utilized, and to help facilitate Middle Fork's proposed development, Middle Fork is additionally asking the board to suspend the general well siting and directional drilling rules, with the exception of the requirement to continue to submit a directional survey. If these rules are not suspended, Middle Fork will be required to seek acceptance locations for almost each and every well it intends to drill. The board has routinely granted such suspensions under similar circumstances. True and correct copies of the 187-09 order and of the rules, the general well siting rule, which is R649-3-2, and the directional drilling rules, which are R649-3-10 and 311, were collectively submitted as Exhibit B. To avoid any confusion or conflict, Middle Fork is also requesting the board to declare all previous wells drilled within Section 16 to the formations covered by the 187-09 order to be at legal locations, notwithstanding the modification requested today by Middle Fork. As you will hear, Section 16 is covered by one state lease in which, as relevant to the Wasatch, Mesa Verde, and Upper Mancos formations, there is common production ownership. Therefore, the requested modifications create no adverse impact upon correlative rights. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5- subparagraph 3B and 40-6-6 subparagraph 6 and Utah Administrative Code Rule R649-2-1. Notice of the request was sent via certified mail, return receipt requested to all royalty, overriding royalty, working interest, and other production interest owners in the relevant formations within Section 16, including the Utah School and Institutional Trust Lands Administration, which administers the state oil and gas hydrocarbon lease at issue. The mailings were sent to the last addresses disclosed by the relevant SITLA, School and Institutional Trust Lands records, and the Uena County Realty records, as well as Middle Fork's internal records. The record will also reflect that notice was duly published on February 3rd, 2019 in the Salt Lake Tribune and Deseret Morning News, and on February 5th, 2019 in the Uena Basin Standard and the Vernal Express. Last Thursday, the division, with leave granted by the board, filed a staff memorandum indicating the division's support of Middle Fork's request. No other objections or responses were received. With that, I'll commence my examination of Mr. Carlin. Mr. Carlin, would you please state your name and business address for the record?
My name is Worth Carlin. We are located at 1515 Wincoop Street, Suite 650, Denver, zip code 80202.
And what is your current position with Middle Fork?
Vice President of Land.
And does that include supervision over the land records, over the lease and the lands at issue today?
Yes, it does.
Okay, would you please provide a brief summary of the corporate and bonding status for Middle Fork?
Middle Fork is a Delaware limited liability company in good standing with its principal place of business in Denver, Colorado. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies.
Since this is Middle Fork's first time in front of the board, would you provide a quick overview of the company so that the board can get familiar with Middle Fork?
Sure. Middle Fork was founded by former Encana executives in early 2017 with an initial capital commitments in excess of $200 million. Backed by equity commitments from Quantum Energy Partners, a well-established private equity firm from Houston with over 95 portfolio company investments across the energy sector. Middle Fork purchased QEP Resources Uinta Basin assets in September of 2018 and has since drilled 4 wells in addition to continuous operations on the former QEP assets.
Thank you. Now I'm going to show you what has been marked as Exhibit C for purposes of this cause. Do you recognize this exhibit?
Yes, I do.
Was it prepared by you or Middle Fork personnel with your input and review?
Yes, it was.
It's also shown on the PowerPoint presentation. Would you please explain to the board what this represents?
This is a regional, this is an oil and gas hydrocarbon lease underlying Section 16, which is owned by the state of Utah and administered by CITLA. They are subject to lease ML 22049, owned by Middle Fork with a 77.5% leasehold working interest, and Crescent Point Energy USA Corp. With a 22.5% leasehold working interest as to all relevant depths. All other production interests are uniformly owned in the relevant formations as well.
Okay, let's back up for a little bit. This map is just a general regional locator map, just giving the idea of where these lands are located in relation to, for example, the Natural Buttes unit and other units that the board might be familiar. Is that correct?
That is correct.
Okay. And the lease you're talking about is in Section 16, highlighted in blue?
Yes, sir.
Okay. Could you please explain to the board what the stars represent?
The stars represent 3 existing wells which were drilled by QEP, which produced from both the Wasatch and Mesa Verde formations.
Okay, and there's a blue outline that cuts through Section 16, blue line. Could you explain to the board what that represents?
Right. That blue line through the southeast quarter of Section 16 represents a unit outline for an enhanced recovery shallow unit.
And that's above the depths that are at issue on the 18709 order and pertain to your request. Is that correct?
That is correct.
Okay. I'm now going to show you what is the original certificate of service. This is a pleading on file in this matter, prepared by my office. Do you recognize the names and addresses shown on that certificate?
Yes, I do.
And who are those parties?
Those parties are the existing owners of the mineral rights and overriding, as well as the working interest leasehold owners and other owners of interest, whether it be overriding royalty interest or other production interests.
In the lease and as to the formations at issue, right?
That is correct.
Okay, and how were these parties and the addresses derived?
They were derived through internal land records, including title opinions and a search of CITLA's records, as well as Uinta County records.
Okay, turning the board's attention to Exhibit Z as supplemented. These are true and correct copies of the return receipts received by my office of the mailing of the request, or of any mailings that were delivered or that were given back to us as undeliverable to the last addresses of records. This was supplemented on Monday to reflect the return receipts received after January 28th, which was the exhibit filing deadline. With that, Mr. Chairman, that concludes my examination of Mr. Carlin.
Yeah, I've got a few questions for Mr. Carlin. Are you familiar with Utah's exception location rule?
Yes, I am.
And theoretically, would it be possible to request an exception location for each of your proposed wells?
Yes, it would be possible.
And do the proposed well locations fall within the parameters in which the division could administratively approve it?
Yes.
Okay, thank you.
I assume no further questions?
Sorry, no further questions, yes.
Okay, thank you. Board members, any questions? Witness? Seeing none. Thank you, Mr. Carlin. Mr. McDonald,
Thank you.
please proceed.
Mr. Castle, would you please state your name and business address for the record?
My name's Chris Castle. I work at Middle Fork Energy Partners, and our address is 1515 Wincoop Street, Denver, Colorado, 80202.
And what is your current position with Middle Fork?
I am the chief geologist.
And do you have the supervision of geologic matters over this area issue?
Yes, I do.
Okay. Would you please outline for the division and the board your education, work experience, particularly any experience in the Uinta or an analogous basin such as the Piceance and et cetera?
Yes. So I've completed a bachelor's and master's degree at Ohio University in Athens, Ohio in 2002 and 2005, respectively. Following my master's degree, I worked as an environmental consultant with ERM in Denver, Colorado for 2 years. Following that time, I returned to school at Colorado State University and worked toward a PhD in sedimentology and stratigraphy, studying the Phosphoria Formation in Wyoming, Idaho, and Utah. I left there to begin work at Encana. I've yet to turn in my dissertation for that degree. I started working at Encana Oil and Gas and worked there for 5.5 years. I spent 4 years working on the Piceance Basin asset, where I worked to being the lead geologist on the Mesa Verde team. And I also spent 2 years working on the San Juan Basin assets and the Gallup sandstones. While at Encana, I was also qualified as an expert in geology in the state of New Mexico. Following Encana, I worked for Terra Energy Partners in Houston, Texas, developing their Piceance Basin assets that they acquired from WPX Energy. Presently, I've been with Middle Fork Energy Partners since June of 2017, functioning as the chief geologist overseeing all of our business development activities and day-to-day operations in the Uinta Basin.
Thank you. With that and the resume submitted as part of Exhibit A, Mr. Chairman, I would move that the board recognize Mr. Castle as an expert in geology for purposes of this cause.
Does division have any concerns about that?
No objections.
Thank you, board. So he is recognized as an expert for the purposes of this hearing.
Thank you, Mr. Chairman. Mr. Castle, I'm now going to show you what have been marked as Exhibits D, E, Substitute F, G, and H for purposes of this cause. Do you recognize these exhibits?
Yes, I do.
Were they prepared by you or Middle Fork personnel with your input and review?
Yes, they were.
Okay, turning your attention now to Exhibit D, which is shown on the PowerPoint, would you please explain to the board what this shows?
Yes, this is a regional stratigraphic image showing the relative positions and nomenclature of the target intervals that we're interested in and their relationship across the southeastern part of the Uinta Basin into the southwestern part of the Piceance Basin, which were deposited in the greater Western Cretaceous Seaway, all in one large geologic system. So if we go from the bottom of the image, working our way up, we work from the Mancos marine shale system, which interbeds with shoreface sandstone deposits of the Blackhawk Formation into the Castlegate and then up into the Sago, where we transition into a more fluvial river-dominated system in the lower Mesa Verde Neslin formations, which contain abundant coals, which are a large source of gas in the basin. Transitioning up into the upper Mesa Verde, we go across a unconformable contact that was exposed at the surface before the Wasatch Formation, which is an alluvial system, was deposited on top of that and then up into the Green River Formation above that.
Yeah, I note that the boxes indicate that there is 10-acre spacing for some of this area. Do you want to address that real quick and how that relates to your request?
Right, so the Williams Fork Formation in the Piceance Basin was set at 10 acres for development and proven by the operations in that basin. And we also have correlative units within the Uinta Basin in Greater Natural Buttes that were also set at 10 acres and developed at 10 acres. And I do believe that Rob Zabak will get into spacing in his portion of.
Okay. All right, turning your attention now to Exhibit E, which is shown on the PowerPoint. Would you please explain to the board what this represents?
Yes, this is a type log and location of the type log map. So on the map on the right, there's a red star, which is the location of this type log. And the type log just shows the interval of interest that we're focusing on. So left-hand log is gamma ray log. The center log, just to the right of the depth track, is resistivity, and the far right log is neutron density. And we go through the Mancos B up to the top of the Mesa Verde.
And this type log was the same log that was utilized for the definition in the 18709 order. Is that correct?
That is correct.
Now turning your attention to substitute exhibit F, would you please explain to the board what this represents?
Yes, this is just a regional structure map around this section that also shows the type log location with the red star, as well as two cross-section lines that are on the following two exhibits. And this just illustrates that we have a calm regional dip of 2.5 to 3 degrees to the northwest, deepening to the northwest.
All right, now turning your attention to exhibit G, please explain to the board what this shows.
This is the west to east cross-section line that was highlighted on the previous map, showing our interval of interest going from Mancos B up to the Mesa Verde, and then including the overlying Wasatch Formation. This illustrates the uniform thickness of the target interval across the area. You'll also note that the log number 2, the OUGB 14MU 16822 well, the log ends at around 9,000 feet, just over that. That's generally the depth of penetration of all of the existing wells in this section. They did not drill through and complete the best part of the Mesa Verde Formation at the base.
Okay, and turning your attention now to exhibit H, would you please explain to the board what this shows?
Same cross-section. This is just a north-south stratigraphic cross-section, also illustrating the depth of penetration on most of the existing wells. And they left behind the best part of the reservoir. So in the lower Mesa Verde and the Neslin interval, there are abundant coals that are generating predominantly most of the gas that we're producing, as well as gas coming from the upper Mesa Verde or the upper Manco system. And they did not complete down into the best part of the reservoir, the prior operator.
Okay. So in your expert opinion then, should the Mesa Verde and the upper Mancos formations be separated out from the Wasatch Formation for development of resources?
Yes, they should.
Mr. Chairman, that concludes my examination of Mr. Castle.
Thank you. Division?
Yes. I've just got one question for Mr. Castle, and I think you've covered it, but I'm just going to ask it for my own edification. So what are the key resource differences between the Green River and Wasatch intervals and the upper Mancos intervals, your target formations?
The main differences
In terms of resource, I mean, you mentioned there was abundant coals which were producing gas.
Right. So
Are these different kinds of hydrocarbons that you're going to be recovering? I know it's a pretty general question, but...
Right, so the Green River Formation is a completely different depositional system. It's an oily lacustrine system, so lake deposit. We're very low pressured in this area, so there are existing water floods to produce Green River Formation. We're not looking at drilling Green River wells at all. The Wasatch Formation this far east, so the Wasatch was being deposited around the Douglas Creek Arch, and we're very proximal to the source. There are not a lot of source rock beds within the Wasatch, so most of the gas being produced from the Wasatch has actually migrated up from Upper Mancos and Mesa Verde below. While we drill those wells, we see very little gas production from the Wasatch. It's just background gas, and as soon as you hit the top of the Mesa Verde, we have large gas shows. So there's just a lack of any kind of source rock within the Wasatch to be productive, whereas when we get to the bottom of the Mesa Verde, at the upper Mancos, we have marine sources of hydrocarbon as well as the coaly gas sources within the lower Mesa Verde.
Thank you. No further questions.
Thank you. Board members? I'll see no questions, and let's move on to your next witness.
Thank you.
Thank you, Mr. Castle.
Thank you.
Mr. Zabek, would you please state your name and business address for the record?
Rob Zabak, we're at 1515 Wine Coop, Denver, Colorado, 80202.
What's your current position with Middle Fork?
Vice President of Development.
And that includes the supervision of engineering matters over this area at issue?
Yes, sir.
Okay, would you please outline for the board and the division your education, work experience, particularly in the Uinta Basin or the analogous Piceance Basin?
Yeah, so I graduated from the University of Wyoming with a Bachelor of Science in Engineering in 2009. Worked for Encana Oil and Gas as a drilling engineer in the Wind River Basin in Wyoming, and then moved to the Jonah Field in the Green River Basin as a completion engineer for about a year and a half. And then I moved down to the Piceance Basin team and worked as a reservoir and completion engineer over that team, managing our reserves database, over 650 BCFE of reserves, coordinating that with our independently qualified reserve evaluators, and then also handled our Niobrara Mancos exploration program. So the Mesa Verde, Williams Fork equivalent over in the Piceance Basin on the reserve side. Then I moved over to Anadarko Petroleum and worked as our exploration engineer, managing exploration projects throughout the Rockies, working in both the Paradox Basin in Utah and the Uinta Basin for Anadarko, working on some projects that we had with our Greater Natural Buttes team and advising on some design of experiments where we modified completion designs to match up with some of the advanced strategies we'd been employing in the Piceance Basin. And then I joined Middle Fork in March of 2017 as one of the original members of the team, and been managing all of the asset and the components for geology and reservoir engineering as we took over the QEP's asset here.
Right, with that and his resume submitted as part of Exhibit A, Mr. Chairman, I would move that the board recognize Mr. Zabek as an expert in petroleum engineering for purposes of this cause.
Vision?
No objections.
Board members? No objections noted. Please proceed.
Thank you. Mr. Zabek, I'm now going to show you what have been marked as Exhibits I through L for purposes of this cause. Do you recognize these exhibits?
Yes, sir.
And were they prepared by you or Middle Fork personnel with your input and review?
Yes.
Okay, turning your attention now to Exhibit I, would you please explain to the board what this represents?
All right, so what we're showing there is the highlighted box is the lease that we're discussing today, and what I'm outlining on the different maps there is the different wells and what they were completed in. You saw the Wasatch completions that Chris mentioned in those cross sections, and so you can see in that far left map that the majority of the wells that were completed in this area were completed only into the Wasatch interval. As we go over into that Mesa Verde completion, what we're showing there is wells that were completed into that lower Mesa Verde, so about 1,800 feet into the lower Mesa Verde, where Chris Castle talked about the majority of the source and where we see the higher pressure increasing into the Mesa Verde. And then as we go to the next map over, it's showing wells that were actually completed in the target interval that we're going after. So there's really only 5 wells within that area that have been developed both in the Mesa Verde and Upper Mancos.
Okay, now turning your attention to Exhibit J, would you please explain to the board what this represents?
Yeah, so taking those same wells that we saw on the previous slide, we're showing the cum plot. So what you have on the left there is your cum gas production versus months on production. And the 3 plots are associated, or the 3 lines are associated with those 3 maps we saw with the Wasatch, Mesa Verde, and the Mesa Verde plus Mancos average well performance. And what you can see is the average well performance from the Wasatch was about 25 to 30% below what we see with when you include the Mesa Verde production. And then when we actually get into Mesa Verde plus Mancos production, you're seeing an increase of over 100% performance over just the Wasatch. So by only drilling up the Wasatch in the current lease in the current area, you're leaving behind a large amount of resource. A lot of that had to do with drilling technologies at the time, where drill times to get down into the Mesa Verde Upper Mancos were very difficult. That has changed, obviously, since those wells were drilled in the early 2000s for a lot of these.
Okay, moving on to Exhibit K. Would you please explain to the board what this represents?
All right, so this is a little bit busy slide here, but what we're looking at on the bottom left plot is a cross-section view of looking into the well bore on the completed interval. So you can see 6 stages were completed in this well. So this is microseismic. Your monitor well on the upper right was monitoring microseismic events. So they're seeing where we were seeing shear events going on as we were completing those different stages in the well, whereas the company at the time was completing the different stages in the well. And then the plot to the upper right is a map view showing the orientation of these fractures. So as you initiated the fractures, your fractures initiate here in the Uinta Basin, we have high stress anisotropy within the Mesa Verde Mancos formations and the Wasatch. And so that high stress anisotropy is driving that fracture orientation to that north 69 degrees west, which is along a similar orientation to what we'll see in the FMI and the borehole breakout. So our proposal here is to align the spacing with the way the fracture orientation is actually occurring. Because this rock is so tight, the fracture orientation is really driving that drainage radius pattern as opposed to just pure reservoir parameters.
Okay, and then turning to Exhibit L, please explain to the board what this represents.
Okay, so teaming up with the next slide, what we see on the far right there is an FMI log, and that's showing your borehole breakout. So the pink dots there are the borehole breakout, and that aligns with your maximum horizontal stress. And then the green dots are going to be your induced tensile and shear fractures when you're drilling, which are going to be along your minimum horizontal stress. And so that fracture orientation matches up. So what we're seeing from drilling with the FMI is consistent with what we saw with the microseismic and what we're proposing for our spacing for our vertical well program.
And if you could address the plat on the left there.
Yeah, so the plot on the left is what our proposed spacing is, and what we see is the drainage ellipse from the orientation of the drainages. So you can see that we're the 330-foot setback north-south with the 1,320-foot setback along sectional line, and then the 2640 setback between wells.
Could you please address for the board how do you plan to drill these wells, the surface use, and how do you plan to drill the wells?
Yes, so from both an economics and a surface use standpoint, out here on federal lands, we prefer to do a single well pad and then reach all of the wells from a single well pad, which allows us to save the amount of land that we're disturbing. So it's been a huge benefit for us working with the BLM in different areas, going to a single well pad as opposed to having individual pad development. It also helps our economics because we localize all of our facilities and all of our different production, tie-ins, gathering lines into a single pad. So it's more economic and it's more beneficial for our surface disturbance from a BLM standpoint.
And one of the consequences, though, of using a single well pad, though, is that you have to directionally drill or use S-curve drilling. Is that correct?
That is correct.
Okay. Mr. Castle on Exhibit D noted the 10-acre spacing for the Piance and 10 acres up in Natural Buttes area, and yet Middle Fork's asking to maintain the 20-acre well density. Could you address that for the board?
Yeah, part of what we were trying to show there is that both the Williams Fork in the Piance Basin and the Mesa Verde here in the Uinta Basin have been developed on 10-acre spacing and shown that you can do that. We think from a north-south perspective, we'll be consistent because that's really being driven by your matrix permeability on what you're seeing drain there. It's not the fracture orientation. We are going to be modifying our completion design versus what has historically been done in a lot of those spacing. And so with our larger completion design, we still need to work through exactly what spacing. We don't think we'll see any communication on 20-acre spacing, so it'll give us a good understanding of what EURs we can get out of the wells. As we get more data and start developing this, we think there's potential to downspace off of 20-acre spacing, but we don't have the data at that time to support doing that until we actually see the larger completions that we're proposing.
Okay, in your expert opinion, then, does the 20-acre density remain appropriate and economic?
Yes.
Is it also your expert opinion that separating the Mesa Verde and Upper Mancos from the Wasatch formations will assist in recovery of resources that would otherwise be left in the ground and thereby prevent waste?
Yes.
Is it also your expert opinion that the requested interwell setbacks will minimize communication between the wells?
Yes.
That concludes my examination.
Thank you. Division?
Yes, I just have one question. So this is the first time that I've seen an operator proposing to drill in this manner, you know, from a single pad. And I'm just interested in how much less surface is disturbed than if you were to develop it traditionally, you know, with 32 wells. I mean, just a ratio, if you could
Yeah, I mean, so if we did 32 wells, you'd be looking at 4 to 5 acre pads. So we'd probably be looking at about 150 to 160 acres of disturbed land. If we go with this single well, 16 to 32 wells per pad, we're looking at more like a 10 to 12 acres. So it's a little over a 10 to 1 ratio.
Okay. And right now you're proposing to drill from a single pad, or are you committing to drilling from a single pad? Or is it, are you anticipating that you're going to have to use more than one pad?
No, we do not anticipate having to use more than a single one pad on this lease.
But it's possible that you may encounter, something unforeseen that makes you have another drilling pad within this section?
No.
No? Okay. Thank you. No further questions.
Thank you, Mr. Kessinger. Board? I see Mr. Kendall.
Assuming this petition's approved, does Middle Fork plan on drilling in the near future here, gas prices being what they are? You just get a take on what your plans are there.
Yes, sir. We currently have an active rig drilling in the Red Wash unit, and so we've drilled 4 wells. We've drilled 8 surface holes to date and 4 completed wells. We're actually running casing on our 5th well, and so we are actively drilling, and we do have this as part of our drilling plan. It really depends on drill timing as to when we will get to this, but our anticipated date right now, obviously subject to change and depending on how quickly we're drilling is really our driving factor now, is late 2020.
Thank you.
Mr. Brown.
Mr. Zabik, did I hear the term S as in Sam curve drilling technology?
Yes, sir.
Could you describe that for me, please? I'm not familiar with that.
Okay, yeah, so from a single well pad, we'll set up all of our conductors, and we set them up in quads where we do 4 wells at a time, which allows us for simultaneous operations when we get to drilling and completions. But we'll set up all those conductors, and then you'll actually kick off from surface. So you'll start going, angling it up to about 10 degrees from surface. And so you'll set your surface casing actually at an angle. You'll continue to angle above the formation of target until you reach that formation. So we've actually stepped out in other fields up to 3,500 to 4,000 feet from that surface location. And then before we actually get into where we're targeting, we'll go down vertical. And then we'll actually complete our entire well bore within our producing formation will be vertical, but we'll have kind of that S curve going down to it.
Thank you.
Mr. Moon.
So my question was similar to that. So you can reach out, you say 3,000 or 4,000 feet.
Yes, we have.
And you actually pump those, or is it natural flow? I mean, you run rods down those and then.
So these are dry gas wells.
Okay.
So they're done on plunger lift. So we'll run tubing in them.
Okay.
We don't have ESPs or rod pumps on them.
Okay. So there is something down there pumping though.
So it's nothing down there pumping. So a plunger lift, I don't know if you're familiar with a plunger. You run your tubing string in. So within your casing, you run a 2 3/8 inch tubing string. And then a plunger is basically a dart that you drop down. It'll have a bumper spring at the base of the tubing that it lands on. And then once you build up enough pressure on the gas, so it allows liquid to go up above the plunger. When you get enough pressure on the gas, the plunger will run up and it'll pull the liquids out. So it'll help to unload the well with liquids. But the liquids here that we're talking about are about 100 to 200 barrels per million cubic feet of water and 8 to 20 barrels per million cubic feet of condensate. So low liquids relative
not much
to
oil at all.
No.
Okay. So my other question is kind of general too. I mean, horizontal drilling for gas, you don't hear about it, but is that even thought of in this area, or?
It's definitely something we're looking into. QEP drilled 8 horizontal wells in the lower Neslin formation that Chris had showed on one of his exhibits there. And so they had good success. Right now, the way we view it, we can drill more economic wells vertically, but we are consistently looking at potential targets. With the way geology sets up in the Mesa Verde and Mancos, that fluvial system is very heterogeneous, and so as you go, those sand bodies come and go over time. We always call it the potato chip model, where you have stacks of potato chips and the sands are coming and going. And so going horizontal, you're not able to stay in a sand body for an extended period of time. So your in zone might be 30 to 50% for a wellbore, which limits that potential. But it is something that we are actively looking into and look at as a potential development plan.
Okay, so there are horizontal gas wells drilled successfully then, and
Yes, yes.
okay.
Any other questions, board members? Seeing none, I guess we're to the point of summation.
Again, at this point, I would move for admission of exhibits A through E, substitute F, and G through L inclusive, and Z as supplemented.
Got it, thank you.
The requirements in the testimony, I believe, satisfy all the statutory and regulatory requirements for granting the relief. I will let Mr. Kessinger provide the division's position, but unless there's something outside of the scope of what his memorandum is, that would be our conclusive remarks on this, and we would ask that the board grant the request as submitted. And thank you for your time.
Mr. McDonald, Mr. Kess?
Yeah, thank you. In sum, ultimately, the division is in support of the end result of this request. In essence, the section should be effectively spaced for 32 S-curve vertical wells or directionally drilled wells. Suspension of the general well siting rule may not be necessary because the division has the administrative authority to approve these exception locations. But of course, this case is unique as it was previously addressed by the 2006 board order that requested suspension of the rule. And given the unique history within this section and uniformity of ownership, extending that suspension down into the upper Mancos may be the easiest to administer for this section and contribute to orderly development. But the board should hesitate before granting a request like this in the future, especially where the relief sought could be granted administratively under the generally applicable exception location rule. Thank you.
Thank you. I see that we have a representative of Sitla in the audience. Would they like to make any kind of comment on this proposal?
Ready? Okay. This is Rulon Gill. I'll be chairing this matter. We're on agenda item number 6. In the matter of Wesco Operating, Inc. We'll take appearances of counsel.
Fred McDonald and Miller on behalf of Wesco.
Steve Alder with Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Okay. I'd like to swear the witnesses at this time.
All right, with me today testifying will be Mr. Steve Degenfelder, who's the landman, and Mr. Tom Kirkwood, who's the petroleum engineer for Wesco.
Full truth and nothing but the truth, so help you God?
Both Mr. Degenfelder and Mr. Kirkwood were so sworn. Okay, we're to you, Mr. McDonald.
Thank you, Mr. Chairman. The vitae of both witnesses were submitted as part of Exhibit A in this cause. Both have previously testified before the board. Mr. Degenfelder will be testifying today as a fact witness only. If they were separately and individually asked about the contents of their respective vitae, they would confirm the same. Mr. Kirkwood has previously been recognized by the board as an expert in petroleum engineering in cause numbers 16609 and 16610. Based on that, his vitae, and presuming the division has no objection, we would ask that he be again recognized as an expert in petroleum engineering for purposes of this cause.
The division has no objection.
Board members, any objection? They are so admitted for that purpose.
Thank you, Mr. Chairman. I also want to confirm the board received the supplement to Exhibit C filed on Monday. That's the additional return receipts, okay?
Yes.
And then also we will be moving for admission of our exhibits at the conclusion of our presentation in chief.
That's our preference.
Ladies and gentlemen of the board, Wesco is seeking board approval to drill the Cane Creek Unit 7-2R2-2620 horizontal well. The well will traverse both portions of the Cane Creek Federal Exploratory Unit, for which Wesco serves as the unit operator, and federal leases located outside of the unit under which Wesco serves as the operator for Kirkwood Oil and Gas LLC and Nerd Gas LLC, the lessees under those leases. Wesco desires to test the eastern productive limits of the unit and determine if unit expansion may be warranted. As you will hear, based on an experience with the division last summer relating to a well proposed along an almost identical path, Wesco was informed that the division would not administratively grant an exception location and conforming APD for the well as proposed. Rather, the division stated that Wesco would be required not only to seek board approval to drill the well, but also to seek a temporary drilling unit for it. Wesco respectfully disagrees with the division's interpretation of the applicable rules, and I will address the legal points in my conclusion. Factually, however, Wesco has secured the written consent of all owners, not only within 460 feet of all points along the proposed wellbore, but also in all sections in which the wellbore will traverse. Furthermore, Wesco cannot speculate as to the potential drainage area of the well until it is drilled, tested, and produces. You will hear this testimony. Wesco desires to make it clear to the board and the division that by filing its request, it is not trying to be confrontational with the division. It simply wants to drill the well. It also is not challenging the division's authority regarding exception locations. It just wants clarification that it has the authority. It's not mandating that the division always will grant an exception location under circumstances. However, this situation clearly establishes that the need for the board direction on how exception location rule as applies to horizontal wells not entirely within a section is to be interpreted, and if and as necessary, for modification of the governing rules. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5, subparagraph 3A and B, and Utah Administrative Code rules R 649-3-3 as to the approval to drill the well. It also has the general authority to waive any of its rules pursuant to Utah Administrative Code Rule R 649-2-1. Should it also choose to issue declaratory relief on interpretation of the existing regulations at issue, which are R 649-3-2, subparagraph 9, and R 649-3-3, it also has the authority to do so in a limited, non-binding fashion under Rule R641-111-100 and R641-111-220. If it desires a binding declaratory relief, it may today only issue a directive to initiate a notice of agency action to that effect under those same rules. True and correct copies of the regulations governing the horizontal wells, the exception location, and declaratory relief were collectively submitted as part of Exhibit B. Also as part of Exhibit B is a true and correct copy of the board's order entered in cause number 166-08, which involved a directionally drilled well which crossed over a unit boundary as well, and I'll address the significance of that later. Notice was sent via certified mail, return receipt requested to all owners within the affected leases in the unit participating area, and to both the state and local field offices of the BLM, which is the lessor under the affected leases and the administrator of the unit. The mailings were sent to these parties at their last addresses disclosed by the relevant BLM and Grand County Realty records, as well as Wesco's internal records. The record will also reflect that notice was duly published on February 3rd, 2019 in the Salt Lake Tribune and Deseret Morning News, and on February 7th, 2019 in the Moab Times Independent. On February 20th, the division filed, with leave granted by the board, a staff memorandum in which it reiterated its position previously stated to Wesco. Of course, Mr. Alder will address and clarify the division's position, but Wesco interprets the memorandum as indicating the division does not necessarily object to the specific proposed well, insomuch as the process by which the approval to do so must be obtained. No other objections or responses were filed. With that, I'll commence my examination. Mr. Degenfelder, please state your name and business address.
Can I interrupt you for a second? I'd like to talk to council about a way to approach this case. As the chair, it appears to me that it's very important for the board to know the background facts, not necessarily your position, but as how we got to where we are today. So the idea is to bifurcate it and to talk about the factual background and where we are, and then to go to the case in chief. Would anyone feel like they would be disadvantaged by bifurcating it? And so the way that would work is you would give us your background of the facts. We'd ask the division to clarify or agree with those. And then I think that gets us to about the noon hour. More than that,
Yeah, I think the best way, I don't know if you want us to summarize the facts, but I would think proceeding with testimony and allowing for cross-examination would be the most complete way to provide you the background you're talking about, Mr. Chairman, respectfully.
Mr. McDonald, do you agree?
I agree with that.
Okay, then let's proceed that way. Okay, to your witness.
Okay, Mr. Degenfelder, please state your name and business address for the record.
Mr. Chairman, my name's Steve Degenfelder. I'm a land manager for Wesco Operating, Casper, Wyoming. Street address is 120 South Durban, Casper, Wyoming 8201.
What's your current position with Wesco?
Mr. Chairman, I'm land manager. I handle all the responsibilities for the land records inclusive of this area at issue.
And what is Wesco's current corporate and bonding status?
Mr. Chairman, Wesco is a Wyoming corporation in good standing with its principal place of business in Casper, Wyoming. It is within the family of businesses owned by the Kirkwood companies. Wesco is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all relevant federal and state regulatory agencies.
Mr. Degenfelder, I'm now going to show you what have been marked as Exhibits C through F for purposes of this hearing. Do you recognize these documents?
Yes, I do.
Okay, were they prepared with your input and review?
They were.
Okay, turning your attention to Exhibit C, which is shown on the PowerPoint, please explain to the board what this represents.
Mr. Chairman, Exhibit C is a regional map showing the proposed well location right within and without outside the Cane Creek unit, which is in Grand County, Utah. Also on the map, you can see it in relation to the town of Moab and the Arches National Park and Canyonlands National Park.
Okay, turning your attention now to Exhibit D, would you please explain to the board what this represents?
Mr. Chairman, Exhibit D is a depiction of the leasehold and the unit boundary and the wellbore location, the proposed wellbore location for the 7-2R2 well. As you can see, the landing point in the paradox formation will be intended to be in the very north part of Section 8 and continue into Section 4.
Okay, and what is the situation on who has the rights to drill within the unit area?
Mr. Chairman, Wesco, as the unit operator, has been designated the operator for wells inside the unit. In addition, the working interest owners, both inside the participation area, as you can see, covers all of Section 8, and then areas outside in Section 5 and even Section 4 are controlled by Kirkwood and Nerd Gas Company, and we also have notification to the other working interest owner in the participation area. So,
and who's that other working interest owner?
Their working interest owner is A.G. Andrikopoulos from Cheyenne, Wyoming.
Okay, and just to clarify, is the entirety of Section 4 covered by one federal lease?
Yes, it is.
And the entirety of Section 9 is covered by one federal lease?
Yes, both of those leases, their lease number is depicted on the bottom of each section.
And both of those leases are owned by Kirkwood and Nerd equally, and they have designated Wesco as the operator?
That's correct.
Okay. Now, turning your attention to Exhibits E and F, there is no PowerPoint for these. Could you explain to the board what these represent?
Mr. Chairman, Exhibit E and Exhibit E and F are the consent to the exception location by the working interest owners in those respective leases that the wellbore will penetrate from Kirkwood Oil and Gas, Nerd Gas Company, and A.G. Andrikopoulos.
Okay. Could you address, as we've indicated and confirmed for it, that one of the potential purposes of this well is to determine the eastern productive limits of the unit. Is that correct?
That's correct, Mr. Chairman.
Okay. Could you outline for the board a little bit of what the process would be and the benefits for unit expansion if the well justifies that?
Mr. Chairman, if the well was to justify a unit expansion, in that the definition of that would be that the wellbore was drilled and was determined to be a unit paying well, then there would be evidence that the geologic structure extends past the unit and would therefore justify the expansion of the unit. However, if the well was drilled and encountered no formation and was a dry hole, similar to the one that we drilled in 2018, then there would not be justification to enlarge the unit.
Will you describe what the unit boundary is on
the board? That the unit, the federal unit that we have here, the Cane Creek unit, requires us to drill and complete 2 wells per year, or the unit will automatically contract. The well that we propose, the wellbore path that is in yellow on Exhibit I, was proposed as one of the 2 wells that we had to drill and complete during 2018. And so you start the process of planning and getting a rig together to drill the other well and this well. And when we had the BLM approval, we set the course to drill these 2 wells. When we did not get the division's approval, we had to change things because we had a commitment that had liquidated damages associated with the drilling rig.
Okay. And is the black line on Exhibit I, does that show the actual path of the well that was drilled, the 7-2R that was actually drilled?
Mr. Chairman, that's correct. The wellbore path of the well that we did drill is shown in black, and we did not encounter sufficient hydrocarbons to complete the well. So we plugged the well back to where it departs where it turns north, we plug the well back, and that's the well bore that we want to utilize for this well in 2019, the 72R2.
Okay.
Mr. Chairman, unfortunately, I add that because our council said that there was ability to appear before you, and we did not, drilling this well, we incurred a cost of several $1 million to find out that there weren't sufficient hydrocarbons there to complete a well. So,
But that was something you didn't know at the time, so you had to learn that at some point, isn't that true?
well, that's somewhat true, Mr. Chairman. That's somewhat true. We didn't have the schedule that allowed us to argue before you, and so we decided to change the wellbore path and go to the north.
And when was that again?
In 2018.
What year, what month, do you remember?
Mr. Chairman, I don't recall that.
I don't know that you need to say,
doesn't
Mr.
matter.
Chairman. I'm comfortable with just an answer without that. Thank you.
It'll drive whoever reads the record crazy. So in Section 8, did you try to produce in Section 8 with that wellbore path?
We did not encounter enough hydrocarbons to complete the well, and the well was plugged back to.
Right. I'm just trying to understand if the portion of the well that traversed Section 8, did you, I don't know how you do it, but did you produce in that section?
Mr. Chairman, can I interrupt here? This is beyond the scope of the direct examination, and plus Mr. Kirkwood is ready to testify to a lot of these matters. He might be a better witness for some of these questions.
I think I'd like to hear what he has, what the division's asking. It goes to my desire to have the board understand the background factual situation.
Thank you.
Let this continue to some point.
Yeah, I'll try and keep it more to the, I do have questions for the engineer, so go ahead.
You understand the question?
I would like to have it repeated if possible.
Yeah, I'm just trying to understand if the portion of the well before it turned north into Section 5, if you had any production or attempted to produce that portion of the wellbore.
To the best of my knowledge, we did not. It's
Okay.
outside really the land department's purview of that, but that might be a question.
Yeah, I'll ask it
partly
again
to
then.
Mr. Kirkwood.
And would it not, you said before you had trouble sometimes getting these wells to go the full length that you anticipated. So just briefly, why did you propose to go outside of the drilling unit into Section 4?
The reason why any wellbore path and well that we drill is predicated on geology and geophysics in the area. We're trying to exploit oil and gas where it is, not. We developed that based on the best geology and geophysics that we had.
Are there other wells that you've drilled on the eastern border of this federal unit?
Yes, there is one that is productive, that is right in the middle of Section 8. It really is the 8-2 well that I had mentioned that is not depicted on the map there. It's inside Section 8, but it's right in the middle of Section 8.
And is it a horizontal well?
It is, that is the well that was drilled approximately 100 or 200 feet horizontally before wellbore and pressure conditions required us to set casing and begin producing the well. The other well is depicted on your map. It's the Long Canyon well that is outside the unit.
And okay, and that's in Section 9. And what kind of well is that?
That is a well that has a cumulative production in excess of 1 million barrels of oil, and it's a vertical penetration.
Just a vertical well then?
Yes, but the horizontal, the well in Section 8, the 8-2 well, was planned to be a horizontal well with a 4,000 or 5,000 foot lateral, and hole conditions and pressure conditions did not warrant that.
Okay. How is production shared within the federal unit? Just briefly, because I'm not sure I understand that correctly.
The production sharing in a federal unit is based on a land contribution.
So, for example, the well in Section 8, is it shared by whoever has the lease of that well location?
The production that was in that would be right in the middle of Section 8 for a very short lateral was the production after the well was drilled indicated that it was a unit paying well, and so the PA, the participation area, was expanded, and that's why the participation area goes up and grabs Section 8 on the map in the red outline.
And that's
Referring to Exhibit D.
Yes, we're on Exhibit D now.
Okay.
That is on the screen.
And is it shared equally with all the owners in that fourth revision of the second consolidated Paradox PA?
That's correct. The fourth revision is an area that is approximately 9,000 acres in size. Every time a well is drilled outside the participation area, after the well is drilled and the production is evaluated, that it's a unit paying well, that participation area expands to incorporate that new well.
And whoever has the lease where that well shares his production with all the other leaseholders in the enlarged participating area. Is that what you're saying?
That's correct, that once the well is determined to be a unit paying well, any leasehold within that well bore and the drainage area is incorporated into the participation area. The same is true, but on a lesser basis, if the well did not meet unit paying quantities, as the well that was located, the horizontal well located in Section 6, that is then a spacing unit and a communitization area is approved by this board and the BLM as the sharing area.
So after you determine it's producing, if it isn't producing, then you come to the board and ask for spacing for that non-producing well based on a formula that the BLM uses. Is that kind of
After the well is drilled, one of three conditions occur. If the well is dry, then there is no need to come back to the board because a spacing unit is not required. If a well is a unit paying well, then the unit would either, in this case, either expand out there. We'd put in an application to expand the unit, and the board would not have to do a spacing unit. If the well is not meeting those unit paying quantities, then we would have to, but it is productive, then we would have to come back after drilling the well and having reservoir characteristics that would demonstrate and justify an applicable spacing unit.
Thank you, that's very complete. So is there a requirement that you drill? I guess you have already said that you have drilling requirements that you have to meet. So the reason to not drill in Section 4, just a 640 acre horizontal well that would have been permitted under the general well siting rule, was that you had an obligation to drill within the federal unit. Is that correct?
I'm a little confused on the question.
So let me ask you hypothetically, why didn't you just drill, other than you had the drilling rig there, but could you have drilled a well in Section 4, determined that it was producing in paying quantities and expanded the federal unit? Or do you have to drill from the federal unit into the outlying areas?
The decision to drill the well from the first well that was depicted on with the black line in Exhibit I was made because we were able to utilize an existing drill pad, the 7-1 drill pad, and we diverted that or used that existing well pad into Section 8 where we made the turn.
Right, I'm just trying, and you've answered that, and I don't want to make this matter go on real long. I'm just asking, do you have to drill from the federal unit into lands that are outside of the federal unit in order to expand the federal unit? Or could you just go to Section 4, drill a horizontal well, and then apply to expand the federal unit? You understand?
Well, we're trying to explore the eastern side of the unit.
Right, that's what I understand. And my question is, the division told you you can't go into Section 4 this way because our rules provide either you can space it or you could have drilled under the general well siting rule of well that was just within Section 4. You chose not to do either one of those. And I'm just trying to understand, could you have done that and still accomplished your goal of expanding the federal unit?
A well that was commenced in Section 4 would not qualify as a unit obligation well.
Thank you. That answers my question there. So how is production shared across? So I guess you've answered. So production from Section 4 would either be shared pursuant to a spacing order that this board would enter subsequently, or it would be added to a participating area.
That's correct, but only once the well is drilled and completed.
Right.
Because this is a hypothetical. When you submit an APD, it says this is how far the maximum length of the well bore would be. We won't know what the extent of the well bore is until it is drilled and completed. It cannot go any further than what we have proposed, but it can stop if wellbore conditions dictate that.
Right.
And we're only going to enter the productive zone at the landing point, which is 1/2 mile from the edge of the unit.
I understand that. So do you save all of the production in a suspense account until a determination is made as to whether it's a producing well or not?
Yes.
Okay.
The sharing starts from the first day of production, and any production that is made during that period until the sharing agreement, whether it's a PA expansion inside the unit or a drilling and spacing unit, which is determined by you, it starts from first production.
So you said sharing starts from first production. Did you mean that the suspension starts from first production, or does sharing start?
I don't understand the.
So is the money that you receive from selling the oil and gas in that well, is it held in suspension until you determine if the well is?
It is held in a suspense account.
Okay.
Suspension, we have suspension of operations and production. There's an escrow account.
I thought you said sharing, so we need to move on because there's a lot of questions. Do you know what additional locations you have proposed for drilling wells that would go outside of the drilling unit? Do you have additional proposals at this time?
We do not have additional proposals at this time. We're trying this as we tried in 2018, but want to try in 2019 to explore the limits of the eastern side based on the seismic that we have.
Okay, and as I understand it, you could not expand or do that exploration by starting outside of the federal unit. You have to start inside the federal unit.
The well obligations that we have inside the unit, which is driving a lot of this activity, it wouldn't be regarded as a unit well if it was outside the unit, and so therefore not satisfy the requirement that we have to drill and complete 2 wells in the federal unit per year.
Okay, just one second. Additional questions? Okay, that's all the questions I have at this time. Thank you, Mr. Chairman, for your patience.
Okay, we're to the board. Do you have any questions about this? Let's start on the right. Left. I have a couple on this exhibit, which is Exhibit D. Just refresh my recollection on unit expansion. Could, once this unit is in place, could you have added Section 4 to the unit prior to drilling this well? Is there a legal or process mechanism to do that?
There is a process through BLM to expand the unit. The reason why we have not done that really is twofold. The time you have to get preliminary approval, and then all the owners in the unit have to approve that or ratify that expansion, and to do that before a well is known to be productive seems to us to be counterproductive in a federal unit like this that is actively being developed, that you've already, it's a federal exploratory unit that is past it's in its secondary term after the PA has been established and production has been determined.
Okay. Thank you for that clarification. And then on that proposed well, assuming that well came in paying quantities, could you just double explain to the board how the allocation of production would occur and what steps regulatorily the state of Utah would need to take to make sure that was allocated to protect correlative rights? So explain how that works.
Right. If the well is drilled to the lateral length that we see, and it is completed as a productive well, and it is determined that it is a well that is in paying quantities, then we would seek to expand the unit to include Section 4 and possibly Section 9, since a little bit of the area of influence intersects Section 9, to include that into the unit, and we would not have to come back to this board, because then the unit agreement would dictate that the PA, the participation area, would expand to cover areas that are thought to be drained by that well.
And the existing PA is mostly based on vertical wells?
No, the existing well is mostly based on horizontal penetrations.
The existing PA is mostly horizontal?
That's correct.
Okay, in the slim chance that unit is not expanded because they don't get enough vote of the owners of the unit, and how would that be allocated? What would have to happen if the unit is not expanded to include sections 4 and 9? How would that be allocated?
If the well was completed as a non-unit paying well, or if enough ratification was not acquired to expand the unit, under those two cases, then we would be back to you to propose a production sharing agreement from that well by all parties that the well bore passes through.
And because you own all of the leasehold interests under federal leases in Section 4 and 9, there would be no harm, no foul, because you'd get it anyway.
That's correct.
Even if it was allocated on a leasehold basis, there's no one else to
That's
share the
correct,
production.
and that's really the basis of our application is that ourselves and the parties in the participation area, that includes that other individual, the AG Andrikopoulos, have all of the leasehold right within the area, the entire area, whether the entire area is penetrated by the horizontal well or only a portion of it. There aren't any other leaseholders in that area.
Okay, I want to clarify in my own mind what the leasehold interest is. I'm looking at this exhibit, and it says Kirkwood, and then another word I can't quite read.
It's a Nerd Gas Company. They're out of Casper as well.
Okay. Interesting name.
It's the McMurray family that discovered the Pinedale anticline and Jonah Field in southwest Wyoming.
Oh.
They just like to have a name that's
So you say Kirkwood and Mr.
Nerd.
Mr. Nerd, okay. Are they joint lessees, or are they
We
two
own-
different leasehold rights that they?
We own 50% of an undivided 50% of that leasehold, and they own an undivided 50% of the.
So there's no question of one lease owner getting part of it and one not getting part of it?
No.
That's off the table. So regardless, then it's either in the unit, is shared under the provisions of a federal unit, exploratory unit, and what's outside of it can be produced either on a leasehold basis or come back to the board for some spacing or allocation.
Because the wellbore will hopefully penetrate several leases, we will have to come back to the board to get a spacing unit because different leases have been penetrated by the wellbore. If the wellbore goes to the proposed length and is not a unit paying well, or is a unit paying well, but the unit for some reason does not expand out there.
So the criteria is the wellbore has to exit the unit for what you just said to be true, or is it the full length?
No, I think that it has to exit or be in
completed
a setback
outside of the unit.
Correct. Yes.
Okay. Board members, do you feel like you understand what's going on? Okay. Any follow-up questions? Okay, thank you very much.
Of Wesco?
Yes.
And this was an email that you received from the Division of Oil, Gas, and Mining, is that correct?
Correct.
Okay. Let's turn your attention now to Exhibit I, which was previously mentioned, but let's go back over this. And I'd like you to kind of give the board, reiterating some of the stuff that Mr. Degenfelder just testified to, but giving them a clear history of what happened with the proposed well in 2018 along this general path.
As previously said, we'd originally proposed the path along the 72R2. We received notification that the division was not going to approve that, and we needed to go through another process. At which point we turned the well north to stay within the unit boundaries, and drilled that well and did not encounter any hydrocarbon shows that would be indicative of a paying well or any productive well in the area, and the well was plugged back. The ladder was plugged back.
Okay, let's back up a little bit then. With respect to the well that was proposed in 2018, did the BLM approve that well to cross over?
We had an approved sundry for the drilling of the 7-2R2.
Okay, and the division did not approve the APD for that well?
Correct.
And are the reasons that they stated to you outlined in Exhibit K?
Correct.
Okay. All right, now let's go to Exhibit, I'm sorry, I think I've got these out of order. Hang on a second. Yes, this is Exhibit G. Okay, turning to Exhibit G, would you please explain to the board what this represents?
This shows the proposed well path as well as the wells that are on a cross-section that is subsequent.
Okay, turning to that cross-section, which is Exhibit H, please explain the significance of this cross-section.
This is the logs in those wells indicated on the map showing the target interval of the King Creek clastic.
And this is in and outside of the unit, is that correct?
Correct.
What kind of log?
That looks like a
Resistivity or what?
it looks like there's gamma ray and total gas.
Right, and why, getting back to Mr. Alder's point, why wouldn't you just do a vertical well? What makes a horizontal well attractive across this?
The main way to produce out here is you need to find naturally occurring fractures. The longer you're in a well bore, the better the chances you have of finding these fractures and making an economic well.
Okay, now turning your attention to Exhibit J, this is a two-page exhibit. Just could you kind of explain to the board what was intended by this exhibit?
The first one is the way the current well bore is set up. It's plugged back and has a 7-inch casing set to just right at the curve where the well starts to turn to the north, and shows the cement plug and then the 7-inch casing that was ran. And the other one is what we would propose the well to look like with a 4.5-inch liner that's drilled and set and cemented.
All right. Again, what's the advantage for you to use the horizontal, the existing well bore, and to the point of the landing point? I'm going to refer back now to Exhibit I.
Currently, with the main advantages is you're going to have a location pad that's already been constructed. You're going to have casing that has already been, hole that's already been drilled and cased. You're also going to have less surface disturbance. In this area, there's a lot of very tough topography that can make access roads and locations very difficult. You're right on top of bedrock in most cases, and a lot of the stuff requires blasting.
And because of the location of this near the national parks, isn't it also an environmentally sensitive area?
Correct, yes.
And you already have the NEPA and all the environmental approvals for the existing well pad, is that correct?
The pad's constructed. And
okay, going to Mr. Alder's question about drilling a well in Section 4, what are the difficulties if you were to try and do that? You'd have to get clearances. I mean, what are the difficulties you would encounter in trying to do a well in Section 4 by itself?
You'd have to construct a new road, a new well pad, and then drill and set your surface and intermediate casing. It is all very hard rock, so it's hammer drilled, which is quite large casing, large equipment, quite costly on that side, and the topography and access to gas sales line is further away as well.
All right, could you please advise the board, what is the status, is Wesco filed an APD or a sundry with either the BLM or the division with respect to this new proposed well?
Correct, an APD was submitted for the 7-2R2, and a new sundry to the BLM has been submitted as well.
When was that done?
The last couple of weeks.
Okay. I think Mr. Degenfelder talked about the problems sometimes with horizontal drilling. Could you just kind of reiterate that In other words, you have a proposed terminus somewhere in section 4. What may alter that ultimately while you're drilling?
As seen on our 8.2 and on Fidelity's 12.1 well, there is massive fractures down there that have overpressured zones, and you get to a point where sometimes you've drilled enough, you just want to get casing in the ground. It's going to be you're pretty sure it's going to be a productive well, and it can terminate at that point, or you can drill, as the case of the 24-2, a couple thousand feet before you find the fractures, and then you've got a longer lateral. So basically, the longer you're in the zone, the increased chance you are to finding fractures.
Hey, are you at this time able to discuss any potential drainage area that could be utilized to either designate a drilling unit or even a temporary drilling unit for this well?
It can be difficult. Generally, for determining drilling and space units, you will have 6 months to a year of production and calculate your cumulative production. Then from that, you'll use volumetrics to determine how large of a circle tangent you need around your well bore for your drainage area.
So in your expert opinion, is the 7-2R2 well required to test the eastern productive limits of the unit and surrounding area?
Yes.
Is it also your expert opinion that the well must be drilled and produced in order to determine drainage, and if and as necessary, establish the drilling unit parameters?
Yes.
And is it premature at this time to set any drilling unit?
Yes.
That concludes my examination of Mr. Kirkwood.
Vision?
Thank you. Mr. Kirkwood, are there other proposed APDs that you have identified or submitted to the division for expanding the eastern edge of this Cane Creek federal unit?
As of right now, this is the only one that would fall under that. Pending the success of the well, with the expansion, you would not need to, but there is a large structure, which is what the Long Canyon has produced out of that is good geologic location for oil to be made.
Has there been a determination of a drilling unit, a size of a typical drilling unit for wells in this formation that are not within the federal unit?
So as in the 7-1 well, which is the well up in section 6, that was a drilling space unit that was determined based upon the production of the well following it being deemed a non-unit paying well. Also down south in the 3 Mile well, there was a Cane Creek 3 Mile unit. There's a Cane Creek well there that has had a CA developed based upon drainage subsequent to production. And then I think 36-2 is the only other well that I'm aware of that did not meet unit paying status that has had a CA formed.
Okay, I'm tempted to ask a geology or a production engineering question, so forgive me if I get this wrong, but you're saying that the production is dependent on running into fractures. And if that's the case, is the production from rock that adjoins those fractures, and is your approximation taking all of the area and dividing it by the production, just a gross approximation, or does it actually show where the oil is being drained from? Do you understand my question?
I guess you're saying if the could you?
Well, I guess the question I'm saying is there a way beforehand to determine the size of a drilling unit if, in fact, the production comes from randomly encountered fractures? Where does the production come from that you encounter in those fractures? Does it extend the length of the fractures?
Yeah, the fractures will be filled, and then there is subsequent perpendicular fractures, and then there's some matrix perm that's associated to to that in the rock itself.
I assume these are fracked wells. You pump sand and water into the...
They are not. Majority of these wells are just completed with a very long perforating gun. There have been 3 or 4 wells that have been stimulated with a very small stimulation. It's your production is bounded by salts above and below, and pumping large water fracs generally breaks up into your salt and can mobilize salt and cause a lot of excess water to be produced. Just what's been seen in the past. We have had some success with a mineral oil and a very small volume frac.
Is there an average length of your horizontal wells or a typical length of the horizontal wells that you drill?
I would say that, there's some that are very short and some that are very long, ranging from a few hundred feet to, 4,000 or 5,000 feet. I would say that, the average is around 2 to 3, but without actually going through and calculating them, I couldn't tell you exactly.
And one more question. Have you foregone drilling vertical wells to develop this area?
Right now, it seems to be there's more success with the horizontal because you do have more time in the pay to find the fractures. That being said, there's been some very good vertical wells that maybe at some point with some better seismic refining, may be determined. But right now, the way that most of them have been drilled is horizontal.
And is there a geologic feature that you think you're at the limits of on the eastern side is there any kind of way that you can determine the extent of this field other than just drilling out and seeing what you get?
We have 3D seismic across it that does show some structures over there to the east. It can also be seen on our cross section where you can see the King Creek going up in structure. The seismic, I don't know where the boundary of it is. I not having it on a map, but there is a definite geologic basis and closeology with other production that there's production over on the eastern side.
Okay. Other questions from the division? That's all the questions the division has. Thank you.
Thank you. Pardon me. Board members, any questions? Mr. Hanson.
I just have one question, and maybe you've already gone through it and I missed it, but the reasoning behind the orientation of projected wellbore 7-2 R2, were you trying to target a particular portion of a structure, or why is it in that particular orientation, terminating near the Matthew Fed 1 well?
A lot of that is we like to go kind of to a known endpoint. It helps you define your seismic and know where you're going to end up while drilling on that. We've also seen there's a little bit more success on east-west laterals than there is north-south, just on a general basis. That being said, there's laterals that are in all directions out there, and some are productive and some are not. It's just kind of you need to have the right geologic conditions there.
Okay, thank you.
Questions? Susan.
On Exhibit E, you show that Kirkwood Nerd, is that owns or is the major leaseholder there on sections 4 and 9?
It's a land issue.
Into the mic, please.
Yes, Kirkwood and Nerd own 100% of the working interest. In fact, 100% of the working interest on the entire wellbore is either Kirkwood Nerd or a small inside the red outline Androcopoulos.
So why didn't you just expand the drilling unit so that you'd be drilling inside a drilling unit?
To expand the federal exploratory unit?
This is a drilling unit. The pink line is a drilling unit.
No, the pink outline is the outline of the Cane Creek Federal Exploratory Unit. And the outline of the current participation area for the fourth revision of the second consolidated PA is the red dashed line.
Okay, what I'm getting at is you own the working interest. Why didn't you expand to 4 and 9 before you tried to drill this, before you asked for permission to drill this well?
The reason why we did not expand the unit before we drilled this well, as I mentioned, was for two reasons. One was that we would have to get ratification from everyone in the unit, and secondly,
but I thought you owned the whole unit.
No, the unit is approximately 40,000 acres in size, the whole Cane Creek unit.
But you own all of 4 and 9?
Yes, we own all of 4 and 9. And to expand, the second reason why we would want to wait until the well was drilled, because this unit is in a development phase, there isn't a reason to expand the unit if the well was dry.
Wells are drilled all the time, obviously, in drilling units, whether or not you know if they're dry or if they're productive. I'm not sure why you would be trying to drill outside of a drilling unit.
But this is not a drilling unit. This is a federal exploratory unit, which is designated as for exploration purposes, and as production is found that is as a unit paying well determination, a participation area is established within the federal exploratory unit. So that is why the red outline is in place there. That is the current participation area and the production sharing area. Any wells drilled outside that area, whether they be inside the unit or they traverse outside the unit, would have to meet a productivity requirement in order to expand that production sharing area.
Back to Mr. Kirkwood. Assuming this well is drilled and that it's productive, how then is your drilling plan going to look when you've, I mean, it sort of looks just helter-skelter. I'm going to drill one north-south, I'm going to drill one east-west, I may drill vertical. Do you have a drilling plan if this looks like it's going to be productive? And what is that drilling plan?
It would be highly unlikely to drill a very close offset to it, because there's not, it's all fracture oriented, and in which case you could be depleting that a set away. I guess it's not developed as a normal resource play is, where they'll come in and they'll drill 10 wells and then frack them all and then bring them all on production based upon the amount of calculated oil in place. This one is fracture oriented, so it's very hard to determine a lot of that. I hope I'm answering.
Can I help answer a little bit of that? Okay. Inside the pink, because there's federal lands, there's a federal program that covers that. As long as the well meets a definition of payout, which is that it pays for itself plus a profit. If it still will pay for itself, or at least recover some of the cost, it doesn't meet that federal program, and then that falls back to the state. So the area in blue on that exhibit is where the well did not meet the federal definition of paying well. And so it fell out of the federal jurisdiction to the state. In the regards to the orange line, and correct me if I'm wrong here, in the orange line, part that is inside the pink is still in the federal program, but it could fall out if it doesn't meet that federal hire requirement. So there's basically, it may be a losing well, but at least it's paying enough to recoup some of your costs. And to be in the federal program, it has to recoup all the costs plus a profit. And so it can be in the federal program or it can fall out depending on what it does. So if my understanding, and correct me if I'm wrong, as to the proposed R2 well, that is part in and part outside of the unit. If it meets the federal level of paying well determination, they'll expand that to section 4 and 9. If it doesn't, then the whole well, inside the unit and outside, then comes to us, and we would have to space not only 4 and 9, but we would have to do some sort of spacing, because it would then fall back into our jurisdiction for the whole well. So you would have a blue, in essence, around that well. Is that correct? Yes. Members, do you feel like you understand all that? Okay. So that's the part where I think we are right now. Would you correct that if I'm wrong?
No, Mr. Chairman, I think Mr. Chairman, I think you completely explained that accurately.
Yes. Your mic's not on.
Probably should already know that. This federal mineral everywhere here. 9, 4, 5, 6, correct?
Mr. Chairman, actually inside the red, inside the participation area, the state of Utah, SITLA, does share as a royalty owner in some of those.
Right, 3 out of the 60. Okay,
that's
but it's
correct.
okay.
They share in some of the royalty. Other than that, it's all federal minerals.
Okay, so there could be some issue of sharing between state and federal, but it's all no fee at all here. Okay,
that's correct.
Other questions? I've got a couple, and please stay here, sir, if you wouldn't mind. What is your understanding of what the Division of Oil, Gas, and Mining suggested that you evaluate, and as you understand it? I think there were a couple of recommendations they made. What's your understanding of those?
Our understanding is that we would like you to.
What did they recommend? What's your understanding of what they recommended is my question.
It's our understanding, council here, is that they want us to propose a temporary spacing unit.
I'm trying to go back further than that. Didn't they originally make some recommendations prior to the first well that went north?
Do you mean the setback from the unit boundary?
Whatever it was, what is your understanding of that?
Well, when we proposed the first, and it was denied by the division, and we changed. They said that we needed to relocate the lateral and observe the 660-foot setback from the unit boundary.
Inside the unit?
Yes.
And as to that, there was a reason why that didn't fit in your plans. Can you tell the board why that advice was, for want of a better term, why was that advice not heeded in your best judgment?
I guess the reason why we proceeded on was because we had well obligations that we had to drill and complete 2 wells per calendar year in the Cane Creek unit, and we had a drilling rig already contracted, and the time frame to come before this board if we wanted to argue or to suggest a temporary spacing unit did not fit our plans. It seemed to be longer than the time frame in which we had to move the drilling rig on there, and so we rerouted the well bore to go north.
Well, in essence, it was timing questions, rig availability. Did I understand anything else was in that decision?
More or less that. Once we discovered that the division wanted us to go down this path, we thought that we try to have the best relationship with the regulatory agencies as we can, and we took a chance. As another member of the board commented about future plans in this area, if geology and geophysics were that definite, we'd know exactly what we're going to do. It's almost like to drill one well and see what the results are, and that encourages you to drill another well. It's not a ubiquitous formation like some of your other cases before you today, where the whole section or the whole area is covered by a uniform formation. These are extremely difficult geologic interpretations, and based on seismic, that many times do not translate into a successful operation.
And now I have technical questions. You said that there's salt involved in this. Is any of this fractured volcanics or anything like that, or what is the matrix like down at the wellbore?
The primary pay is a dolomite, and there's the King Creek is a stack of anhydrite, shale, and dolomites with a salt above and below, a capping salt.
And that's the potash type salt.
There is potash further uphole, but it's just.
That's not what they're using for the potash operations. Just I think it's east of you.
Yeah, they use it
west of you.
Correct. Yep, they have a shallower. There's layers of potash strung in the salt, and I think there's some potash up shallower that they're mining.
And I have a two-part question. First one is, do you have an idea of the fracture orientation, and or is it just pressure type fractures?
A lot of them are fault based, so it's very.
Okay, the L is the new one, correct? I don't.
Hang on a second, maybe.
Let's double check L, and I don't remember your referring to Exhibit K.
Excuse me, it is Exhibit K. Exhibit K was referred to by Mr. Kirkwood, that it's an official business record, and it's also the response that the division gave why they were denying the APD last summer. And you're right, it's A through.
Said that it would be limited to the facts, that it was a pilot project, and that the order would not have precedential value. That's one case that I know of where the same arguments were made about using the exception location rule.
And that was the point I was going to make. We want to hear your full arguments, but we wondered if the board, in past experiences, when it was a matter of first impression where the facts aren't known because the wells aren't drilled, has used the pilot project authority till it could get to a point where it could make an informed decision. Would you address that in your arguments as well, please? Both sides.
Try to. Okay. Again, I'm going to reiterate the point that the primary goal today is getting authorization for Wesco to drill this well. I don't think, based on what I heard from the division, that's at issue anymore. It really shouldn't be questioned that the board has the authority to do that regardless. The real issue comes in interpretation of antiquated, which I think the division would agree, antiquated horizontal rules that are in place. but this is what we have to deal with right now. R649 3-2, subparagraphs 3 through 8, set forth the horizontal well rules in the absence of a special board order. Under subparagraph 3, it says that you can be no closer than 660 feet to a federal unit boundary or a boundary line of a lease not committed to the drilling of a horizontal well. Okay? There's no mention of a governmental section being part of that. Secondly, subparagraph 5 says that a horizontal well can be located no more than closer than 1,320 feet to a vertical well in the same formation, not a section, in the same formation. That's different than what the division set forth in their memo. The only mention of sectional concept in a horizontal is subparagraph 6, which says that a temporary drilling unit of a 640-acre governmental section is set. However, you need to understand that the definition of temporary drilling unit in the regulations is as follows: a specified area designated by the board for well density and location. It does not it expressly is not a drilling unit under 40-6-6 and does not provide a basis for pooling. In other words, it doesn't define correlative rights. It's a notification rule. And that's set forth in subparagraph 7 that says when you file an APD for a horizontal well, you got to give notice to all the owners within the temporary drilling unit. Okay? The purpose is to ensure that the people who are potentially affected by the horizontal well are notified. Like I said, under subsection 6, that's the only mention of any kind of concept of a sectional limitation on it. Subsection 8 deals with horizontal wells within a federally supervised unit, and they're exempt from the temporary drilling unit and the notification rule. Subsection 9 is the really key one that you guys need to focus on in the issue here. It expressly provides that the exceptions to subsections 3 through 7 may be approved pursuant to R649 3-3, which is the exception location rule. When you get to that, it says that an exception to location and siting rules is when there's written consent from all owners within 460 feet radius of the well location when such exception is to the requirements of R649-3-2. It doesn't say any subsection of rule R649 3-2. It doesn't say, well, you can't get an exception location for horizontal wells. It doesn't say, well, you can't get an exception location for the sectional temporary drilling unit requirement. It doesn't say, well, you can only get setbacks, an exception if you're within the 660 feet and you're still within the section. And it doesn't say that it only applies to vertical or directional wells. It says if you meet this criteria, you have it. So the question here is the division said they didn't have the authority to grant an exception location, and my argument is under the existing rule, it does have that authority. I'm not saying it has to exercise that authority if there are other reasons why it shouldn't be done. In this particular case, I think we've set forth the facts saying this is exactly where an administrative exception location could have been granted. So that's the question of coming forward. The problem I have with the division's interpretation of it is if you have to drill within a section of a horizontal well, why would you even need an exception location rule for a horizontal well outside a section? You wouldn't need any of that exceptions to apply. You'd have to follow those rules for the temporary drilling unit and staying within a section. Excuse me. Yes, within the temporary drilling unit. Okay, so let's go back to the basics here. The board's job is to maximize natural resources recovery while preventing waste and protecting correlative rights, okay? Let's go through each of those. Well, allowing these wells, particularly under the circumstances that were testified today, allow the exploration to determine if there's productive intervals outside of this unit. There's geologic and technical reason and justification to do that, okay? Let's talk about waste. This is the only well that's being drilled in this area. The next APD that comes through, if the division thinks there could be any impact that would be wasteful or potentially protect or impact correlative rights, they could deny it on that basis and not allow an exception location. In other words, that would be set. Also, if the well is productive and it's not part of the unit, we're coming back to you for a drilling unit, and that drilling unit will establish the appropriate setbacks to prevent waste at that point. So the waste is being prevented. Correlative rights. In this situation, every single owner who has the right to drill, not only along 460 feet, but along the whole section, along the purposes of that well, have agreed to this. So whose correlative rights are being improperly impacted? As far as production allocation, Mr. Degenfelder set it forth. If it's a unit paying quantities well, it may expand the unit and become part of a participating area, and that's a voluntary agreement that everybody shares on that basis. If the unit can't be expanded, or if it's a non-unit paying quantities well, we come back to you, you set a drilling unit, which then defines correlative rights, and the allocation will be as set forth in that spacing order, based on that spacing order. So in this situation, all those are taken care of. I want to point out the 16608 order, which we submitted as part of Exhibit B. This is a prime example of how this would work. This was a directionally drilled well, but I don't see the distinguishing factor there, that started out in a federal unit and ended outside and crossed the unit boundaries into a federal lease that was adjacent to that. And in that circumstance, an exception location was granted. And then when it was determined that the drainage occurred from that well, the operator came back to the board, got a drilling unit, and the production's allocated between the unit participating area and the lease outside of it. That's exactly how this would proceed, the only difference being a horizontal well versus a directionally drilled well. So in this situation, I think it's very clear that we believe the division does have the authority, it does have the right to exercise that authority and kick it up if there's good reason. But it also shows the problem with it is the board has said many times they want the operators to know what the rules are going in. Well, you have existing rules. We believe the rule is very clear that an exception location can be granted for a horizontal well under these circumstances. And we want to make sure that the division understands it has that authority. Now, if you want to state that, and this gets to the declaratory relief situation, the rule is very clear on what you have. You can either reject making any kind of declaratory relief based on the regulation, but I think we've pointed out that there's problems with the regulation. Number two, you can issue a non-binding limited to this matter ruling that, yes, the division had the authority to grant an exception location here. Or if you want to make the general statement based on the current regulations, it would have to issue a notice of agency action to give notice to the world, this is how the regulation is going to be interpreted. Or, which I agree with Mr. Alder is, probably the better idea is to initiate rulemaking and clear this matter up and bring the regulations up to date. So those are the three factors that on the declaratory relief the board can do. So again, just to reiterate, our main purpose today is to get this well approved so that they can drill it. The other factors on it, again, we just believe based on what was submitted prior to today that the division stating it did not have the authority is not a proper interpretation of the regulation, and it's a question then from the board how they want to proceed in addressing that matter. So I thank you.
Mr. Alder.
Thank you, Mr. Chairman, Board, Mr. McDonald. I think that we all agree that part of the reason we're here today is that the horizontal rules and the horizontal drilling is ahead of the horizontal rules that we have. We do have horizontal rules that allow for exploratory horizontal wells to be drilled. Those rules were adopted at a time when most horizontal wells were shorter than a mile, and I don't think there were any that were 2 miles. And so it allowed an operator to drill a well within a section without spacing, and they could determine some attributes of the pool and then come to the board and space those lands and develop that section. We now have operators who routinely have the capability to drill longer than a mile. And in this particular instance, with this particular field, reason to drill at odd angles to the regular federal section. So they're drilling across section lines. The current rule doesn't allow for that. It provides that horizontal wells without spacing, so some kind of exploratory or wildcat development by a horizontal developer, has to be within that section. The circumstances under this case, I think, can be narrowly limited to the fact that we have a very unusual geologic area where the production is somewhat random. We have a lot of wells in this area, and yet we still can't get a definition of a drilling unit from the operator. It's just drill wells a certain length and see what you find, and then divide up the production that you get from that well among the acreage. So either that or use the federal system, and it's working okay. So this is really an exception to the standard situation, and the rules were adopted before, and not for this particular situation, but for the standard situation. And they provided that absent spacing will allow people to drill vertical wells or horizontal wells on a predetermined distance apart from each other and from the drilling unit boundaries, and then they can come and get spacing. Now, there is an exception location rule, but the exception location rule, I think clearly read, is not to allow any well to be drilled anywhere that you have 100% approval of the owners within 460 foot of the well bore. It's exceptions to the general well siting rule and or exceptions to the drilling unit order. And it is, and so when you have section 9 that says that for horizontal wells, you can use the exception location rule to accept the requirements of the general well siting rule, it makes perfect sense. It certainly is possible that you're going to drill a horizontal well that's going to be closer to another well or closer to the drilling unit boundary, or maybe you don't want to give notice to everybody. For some reason you think you can get around doing that. So the exception location rule does apply to those specific requirements in the general well siting rule. It doesn't make sense to take that exception, which says it's an exception to the general well siting rule, and say, therefore, it's an exception to any of the requirements. You can drill a well across a boundary or across or outside of a boundary under the exception location rule. We really just need to update our horizontal drilling rules. I mean, it is kind of a shock that we've been doing horizontal wells for 10 years, and we still are kind of doing it mostly by spacing on a hit and miss basis, and we have no, I mean, it would be a very simple thing to perhaps expand our general well siting rule to say it could expand across 2 sections, but that's not what we have right now. So that means that this matter has to come to the board either under the exception for a federal unit, which routinely happens where you suspend the rules, or it comes to the board under the exception location, and the board can hear the facts they did here and can grant that exception. I know I argued that it would be inappropriate to grant the exception outside of the drilling unit or outside of the spacing area, but I think in this circumstance the well is really staying within one section, and it's within one section of the federal unit. I would urge the board to limit its order approving this, just as they did in the KGH matter, to the specific facts, and then try to maybe, if there's a way to extrapolate for similar situations, that the board can approve those as well, so that the operator has some predictability as to what's going to happen. But it is not appropriate to allow the division authority, because the division isn't going to have any idea if it's limited to these specific facts, or if every time an operator comes to them with 100% consent, that they have an obligation to approve that well. If that happens, the board loses its control that it exercises under the spacing or the drilling unit, the spacing orders that it issues to determine the orientation of the wells, to determine the length and make sure that everybody's noticed. It would just turn the board's business over to the division in a haphazard way, and I would strongly advise against it. As to the declaratory relief requested, then we would ask that the board determine that in this matter the board can find that this well is appropriate, that the division cannot, and that it not, if it wants to proceed with a declaratory order of some type, there's no reason to find or make that finding here. You can simply initiate rulemaking, which is what would happen anyway, which would then allow us to either on a limited basis establish rules for exception locations for horizontal wells outside of federal units. I mean, that would be a simple category. Or exception locations longer than 1 mile. That would be another category. Or maybe perhaps we might find the time to actually do a horizontal well rule. But I think it would be really just inefficient to try and order declaratory relief in this matter. Thanks.
Board members, could you give me a little attitude here? What I'd like to do is throw out an idea, take a 10-minute break, have counsel for both sides talk about it, and come back and discuss it. And then we would go in and then deliberate. Or would you rather have closing arguments and just go deliberate? Hearing none. What's that?
Go ahead.
Here's the idea, and I'm speaking for me, not the board. The idea is we want this well drilled. Apparently there's no disagreement about that. In similar situations where we don't know enough to make an informed decision in terms of how the facts are going to develop in any number of different ways, we've taken a pilot project approach where we have a pilot project order. It has a sunset date. It has no precedence as to the future. It could be limited to this particular set of facts and to this particular field. Because it's a pilot project, it would have no declaratory order needed. Rulemaking would be encouraged for longer than 1 mile horizontals in this factual situation where you have an inside-outside of a federal exploratory unit situation. I'd like to have you guys talk about that and address it when we come back in 10 minutes. Board members, do you agree with that approach? Then we can go and make a deliberate, knowing that we have discussed this rather than trying to make that an option without input from council. Okay, seeing none, then we will go have a 10-minute break. We'll be back here just close to 10:02, maybe a 12-minute break.
what I want to do. Even though, and this could be whether this is contracted or not, let's assume this unit is still active. And they've drilled 2 more wells, and they're going to decide, we'll wait to find out live whether this is going to be another PA. This one, it turns to be going to be a PA because it's not such a well. We cannot pay for its cost. Sell the oil, and nobody is upside down as well. Nobody pays 40 grand in, and is only going to get 20 grand back. He'll get his 40 grand. But you can't restrict that on one unit agreement because it's not a great well. So this is pretty in this well. If that's the case, and this one, and that's going to have to turn back and ask them to space it because you have to have a basis to distribute the production from this well. And the basis can't be the unit, it has to be, that's no longer a unit well. And imagine what you have is if you look at it as a plane, right? Here is all your unit, here's your unit, here's all the unit wells, right? Well, now you drill a Yates well, and it's like, Yates well is like floating, it's like you've got 2 different sets of rules and regulations and everything. Right, exactly. So they go over. But there's an exception. That's a Yates well. I can come and ask you for a unit because the issue is that you cannot ask all the there's the well section. How do we distribute? Because no, we cannot. It's not an agreement. It doesn't cover that. It's not covered by that agreement. It doesn't matter what the agreement says because in order for this well to have an allocation based on the agreement, it's got to pay costs. If it only will pay costs, now someone can come in and say, okay, we cannot get other people in the unit to decide if it is just a case. So we're going to ask the state to do that instead for us because we're not subject to this contract. Yeah, it's fucking literally, that's like, because I've been doing this for 20 years and I learned new shit. That's so crazy. Like, yeah, it's complex. I think that was the best for it. I was like, oh, units of fields, that was that. And it's just the same thing like what I'm saying, like unit section of the state law. It's called water flood. Secondary recovery. All right, yeah. That's the same thing. Secondary recovery units under state law, they were for, and you can create a federal secondary recovery. What that is for is what you're saying is, hey, wait a minute, you've gone to this area, you have all these wells that are in state spacing, and you drilled all that out. I'm sure it is. And now you want to go and inject water in there, get right. Resurrection life number 2 for these wells. But I think the state says the same thing. You shouldn't have to worry about all of this line, everything here, water flood is really complex. So you come to me and you tell me you want water flood, and then I'll water flood inside of our and I treat this piece of property, this piece, and this piece, and this one over. I can treat all the site. I can do whatever across here. That way it doesn't matter. Oh, you're saying because it's all together and there's an agreement that covers how we're going to, it covers how the parties are going to get together and decide how to split everything up. Yeah, so the well is not covered by that agreement anymore. You have a third party to come in and agree. And so what you can either do is get everybody to agree to sign the JOA, and then come to the board and get everything, but you still need to agree. You just want to use JOAs and yeah. And that governs allocation and stuff like that, but then you still, so in other words, you can get the parties to agree to allocation, but the easiest way to get them to agree to that is to say, the state has given us this spacing. But I don't agree that this well is drained from the 40 and we should all be, our interests are all 640. It could be just and they'll all say sure, because their state has said that's what it is. Expansion. Yeah, I'm going to go through all of them. We don't have very good estimated boundaries. We have the DLM one. We go up to I think that's what that's why unless it was to there's tribal the question is what is our responses? Because they're a sovereign nation. Yeah. Yeah, I see you created all this stuff on it. Because then if you sovereign land, all of it's garbage. Well, throw them all. Well, then, get rid of them. I don't really care now. Obviously, we're gonna do. That's check. Yeah. Like to get paid. But they can always do that. And to be honest, I've always looked at it as a 2 to tango. And this is what we do. But I represent a tribe of 6 or 9. I have the tribe pass a resolution, spacing. That would be a good question. And I take that resolution, and I use it as an exhibit. Keep saying it. Have you thought about it? I didn't hear your question, but you already said it was a good question for Fred. I was thinking about what happens if you give a It says it's 1280 to the extent the tribe. We can fix that. We need to have a. That would explain everything for you. No, probably will. And the tribe's never gonna do anything because they've made a resolution that says, here's how we're gonna. Section, this is the box that this well is draining. And we have this. Is that a lease base? That works. They used to do memorandum. So if you expand and incorporate that well into the PA, you can have outage. If the state spaces something, yeah, we're all in and we agree unless we object within 5 years. So, you know, or something. It's pretty simple. You can just have it. No, it's hard for me. We have these boundaries around my cable. So I'll give you a good one. I'll give you a good one. Just let's do it. The NDIC has a procedure as to the lands that overlap with I'm gonna grab some of one tangent. I can go in and now I have a presumption that your AP should be ready to revoke and allow me to file. If it's already started, it gets worse. If it's already started, there's a rule that lets me say, I'm further down. I'm just gonna say, and you're well, why would you bring in sections? You want the board's gonna determine how much money they owe you for all that. But that's not mine. Them to decide if you got the codes. That's how that works. So here's what happens. We go. Well, it's still gonna be a line on the suspension of revocation. The answer is that if there is a majority, I've never seen a majority not prevail on one of those hearings. So they went and they said, what they did is they said, RDGs allowed other guy to file this and gave them 9 months to go drill the well. Because you may or may not influence.
All? Council? Okay, we're back on the record. The board was kind enough to give me some latitude to fashion an idea. The board would like to hear your response to that idea, recognizing that I think everyone would like to get this well drilled. Well, who would like to go first?
I'll go first.
Okay.
As far as, again, the ultimate goal for Wesco is to get the well approved. So whatever it's going to take to get the well, the authorization to drill the well, that's the most important thing. I do want to express some concern with framing this as a pilot program because I'm not sure what is going to develop from it. In other words, if this well, as we've talked about, meets the unit paying quantities definition, then, and everybody's in agreement with expansion, it'll become part of the unit, and there would be no need to come back to the board, you know, for any dealing with the well. If the well, either you can't expand it because you don't have enough consents, or it's a non-unit paying quantities well but still producing, Westco has stated it will come back to this board to get a spacing order to address all the issues that you would need to address with that well. If it's a dry hole, there's no need to come back. So I guess the question is does it really need to be framed as a pilot decision? If it's the board's determination that they don't want declaratory relief but want to initiate the rulemaking, that's your own prerogative with it. But in my view, that you can either issue an order that approves the well under the authority you have and then addresses the issue if you want to make it, you know, that you will come back to the board for under these circumstances, and then however else you want to frame, whether it's part of this order or something else, depending on the declaratory relief, that's kind of up to you. But my concern was with the pilot. But if that's what it's going to take for the board to approve and get this well drilled, then my client says, okay, label it a pilot program if that's what's necessary.
Division?
The division, although I haven't consulted with the division because it's mostly a legal question, but we talked a little bit about this and agree that it's probably also not something where labeling it a pilot project would be that helpful. I mean, there's been a lot of wells drilled in this area. I think it's pretty clear that the operator and other operators who have been before the board over the number of years understand that this is a sort of a chaotic play, a lot of variables, but we kind of know that. It's sort of hit or miss. And so making it a pilot project isn't going to help establish parameters for future spacing. I think one of the things that I wish I'd thought of before, and Mr. McDonald didn't say he would oppose this, but we have suspension of the rules allowed for federal units. And what we're really doing here is looking at drilling around the perimeter of federal unit, and it seems rather than allow an exception location, which I find sort of an open door that doesn't have any clearly defined parameters, it would be better to suspend the rules for this well because it's in an attempt to expand a federal unit. That's sort of logical and consistent and limited. And so we would suggest, rather than calling it a pilot project, approve it as a suspension of the rules as the board has authority under both the board rules and under the, although the oil and gas rules say it's the director, I think the board also has authority to suspend the rules along the lines of a means of expanding a federal unit. So, but we would say no to, and as far as rulemaking goes, we all know we need to do rulemaking for horizontal wells. So I think rather than limit it to this specific order and this specific type of situation, let's just do horizontal drilling rules separately and approve this one as a suspension.
Can I ask some board members, would you mind if I ask some questions, or would you like to go first? Your mic on.
I'd like to know how you feel about that suspension. Does that accomplish getting the well drilled?
Yeah, I mean, again, there's always there's the question, and I thought I heard Mr. Alder acknowledge that the board has the authority to grant it as an exception location. And then there's always the broad authority that they have under Rule 649-2-1 to suspend the general rules for good cause shown. So that's a possibility for the board that they could consider. That's the consideration. That gets the well done. Like I said, it doesn't resolve the problem of the way that the current regs read and how they're interpreted.
Back to some of the specifics that I talked about. So a sunset date on this order could occur if there's a unit expansion, could occur if it's a dry hole. If there is a need for a spacing order, then this order could say expire after 1 to 2 years, so that it gets you back before us. As far as the no precedence, if the board wanted to declare that this is not for precedence purposes, that was the idea behind the pilot project. We could declare that as my, I believe that both parties would agree to that. Is that true?
Yes, and under the declaratory relief, that is one of the things that you have, is that it's very limited to the specific case and facts. It's one of your options.
I think there's also a factor in this where we want to learn what's down there in that field on the edge of this federal exploratory unit. What about a report back to the board of what you learn or what it is that you're finding about this fracture orientation and this, you know, there comes a point where we've got to have enough information as these proposed new rules come along that we can make informed decisions. And then what's your response?
My client said that they'd be willing to report back as long as it can be provided confidentially.
Correct. And then in terms of rulemaking, we can say we would order rulemaking, or I think my preference would be to say we encourage rulemaking in this matter without putting a deadline on it. Board members, is there anything else you would like to bring up and talk about that? Okay, then I think we're back to closing arguments. Mr. Alder, can you make yours, and then we'll go to Mr. McDonald if you haven't made them already.
Well, it's late in the day, and I think the board understands the issues quite well. If I argued, spent a lot of paper and pen on why the exception location rule should not be used, and if it is, that it should be limited to the specific facts. I think after this hearing and understanding the relationship between drilling outside of a federal unit, that a better answer would be the expanding of the suspension rule to approve this well, and I would recommend that as a decision. Thank you.
McDonald.
I don't have anything further that's to add on this.
Board members, we'll take this under advisement and stick around. We'll be back.
You approved it and did not object. Thank you. I don't want to. It's Steve. It's Steve. So same guy we had 4 months ago. Well, those are good wells for us. They are. They killed that dude. The one came on. This right here? Yeah. It's a strange state. I mean, we were anticipating. We just work on that. Killed it. I mean, they're on the west end of the base. And like I said, the only problem, the only issue we had to do with those things is when the commodity price starts peaking, right? So where we're at right now, nobody's ever gonna say, oh, you know what, go ahead and shut that in until the price goes up. Yeah. That's not happening now, but we all know, once that price gets $28 or $30, all of a sudden people are like, do you really have to put this stuff right now? Does that lease have a shut-in royalty clause? This is costing me $30 a barrel. You know? So yeah. Oh, we're looking forward to another power. You want to hook us up with one more? That's pretty exciting. I already worked out a starter trust because we had pretty good selection. Somebody run my voice sensitive. I don't know the social issue. Building's not supposed to be dark. We have got they got the second suit of armor. No, there's 2 of them. We just didn't have one problem. The staff had a bunch of information cables and surface location Cache Valley Electric. And it was more than our building too. Smith's, this is all over. All of this is so.
Hey, Paul, are the mics on?
Okay, we got, well, there, council, you ready to go? We're back on the record. The board has deliberated and come to a decision. Mr. McDonald, we're going to ask you to take the first draft of that. We're going to ask then Emma or the board and the division then Emma's going to eventually own this order, but we'd like you to take the first crack at it. The order is basically this, and Emma I think understands this better than I'm going to say it. The order is that the well is approved, subject to the following. There will be a sunset date on the order. It will have 3 parts. If the federal unit is expanded, then the order would sunset. If the well, the R2 well, is a dry hole, the order would also sunset. If the federal unit doesn't expand to cover the lands involving this well, then this order would have a 2-year sunset and could be extended by application without a hearing for an additional year. It would encourage you to come to the board to get whatever relief our rules and laws would require. Second element, this order would have no precedence Therefore, it doesn't need to be limited to this fact situation or this unit. We would like a yearly report that would give us the information about development plans and lessons learned. I don't know that we need to know the proprietary nature of this. The year report we're thinking of would be more in the line of what did you learn in terms of this well and future development. To the extent necessary, we deny the request for declaratory order and instead encourage rulemaking that would deal with the facts of this situation regarding a well inside and outside of a federal exploratory unit, and that may be as long or longer than 1 mile. And to make sure we have that on the record, I need a motion to approve that. Is there a second? Second. Okay, we have a motion and a second to approve what I just stated. Is there any discussion of that motion? Any clarification that council needs before we put that in final so that the board is clear about what you understand this to be? And Mr. Alder, do you have one of those?
Yes, the division understood from the testimony that the federal unit may expand and yet still not be included in a participation area, in which case they would have to come back for spacing. So the question was whether or not, when you say federal unit expands, do you mean fully expands to be part of a participating area?
Good point. What we're saying is that there are two regulatory regimes, the federal regime and the state regime. If the federal regime does not apply to the two sections outside of the well, pardon me, outside the exploratory federal unit, then our regulations would apply. So by saying expansion, we meant the federal scheme. So you're saying it better than I did. Okay?
Okay.
If our regulations apply and our statutes, then you have the 2-year sunset. If the federal scheme applies, then the order sunsets automatically because it's no longer necessary. Is that a good way to say it? Okay. With that, board members, all in favor say aye. Aye. Any opposed? Let the record show that that's unanimous. Thank you. We're going to move on to agenda item number 7, docket number 2019-008, cause number 140-17. And for clarification purposes, while you're getting ready, I want the record to show that the last matter with Wesco was docket number 2019-007, cause number 166-11, in case there was any ambiguity. And council, would you let us know when you're ready to proceed?
Yes. Sorry. Should take just a second. We have
take the time you need.
We have a Skype witness, but I don't think our presentation is going to take more than 25
So we're off the record for a minute.
Texas, can you hear us loud and clear?
Yes, we can.
Okay, thank you.
We are still off the record, but board members, when we approved the remote testimony, we required that they have a certain level of electronic sound and video. And I believe EP has taken all the necessary steps. But one of the things that we're continuing to work on is to make sure we are able to set those requirements to a level that meets your needs. So we're going to use this hearing as kind of a test of that. So if you're satisfied with the quality of the audio and the visual, the video, then we'd like to kind of just get some feedback. We think this should be excellent, but they have met our requirements.
So, Mr. Chairman, I should probably tell you, I go to other places, and it's 4 people in another state sitting around a conference table. We're 2,000 miles away. Everybody's arguing about which exhibit it is and who's on the phone, and this is fabulous. Like, everything, like, this is fabulous.
Well, and then you let us know. I mean, you know, the kind of the goal here, again, we're off the record. The goal here is, even if we get it right, how could we have done it better? So that's kind of the continuous improvement. Vice versa from Texas, if you like to get kind of off the record comment at the end how this has worked for you in terms of remote testimony and things like that.
Okay.
So why don't you let me know when you're ready and take the time you need.
I am ready to proceed when Mr. Biancardi is ready.
Mr. Alder for the division.
We're ready.
Leanne, Michelle? All?
Yes.
We're back on the record. I'd like to take appearances of counsel at this time. To double check, I believe I read this in as docket number 2019-008, cause number 140-17. Is that correct?
That's correct.
Okay, we'll take appearances of counsel.
Brent Chicken, Steptoe and Johnson.
I'm not picking you up on this. Hang on just a minute. Let me make sure. Try that again.
Brent Chicken, Steptoe and Johnson, PLLC, on behalf of EP Energy EMP Company, LP.
Steve Alder and Thomas Kessinger, Utah Attorney General's Office for the Utah Division of Oil, Gas, and Mining.
It will take swearing of witnesses at this time. Why don't you, Mr. Chicken, read the, do you have more than one witness?
We only have the one witness.
Okay, so for the record, we are in remote testimony. The witness has stood, and we're going to have the oath administered at this time.
Will you raise your right hand, please?
Yes, ma'am.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you very much. You can be seated. Is this witness going to be a fact witness or an expert witness?
He's going to be both. He's going to give basic land testimony on where the wells are located, which he's capable, certified to do. But he's also an engineer for EMP, and he has been appeared before the board many times as an expert witness.
Thank you. So let's have him. You proceed as you want, but it would be our preference that he be qualified at this time.
Certainly, I can do that. Mr. Biancardi, if you could please state your name, your employer, and your work title for the record, please.
Yes, my name is Stephen A. Biancardi. Spelling my last name is B as in Baker, IANCARDI. Work for EP Energy EMP Company, LP. The address is 1001 Louisiana Street, Houston, Texas, 77002.
And Mr. Biancardi, have you been qualified as an expert in petroleum engineering by the Board of Oil, Gas, and Mining in past matters before them?
Yes, I have.
And have you submitted as an exhibit prior to this hearing an updated resume of your education and qualifications?
Yes, sir, I have.
Subject to any voir dire that the board or the divisions council would like to make, I'd like to, based on his prior qualifications as an expert in petroleum geology, I'd like to ask that Mr. Biancardi be so qualified as an expert for these proceedings.
Division.
No objection.
Board members? Objection? Okay. He's so admitted as a petroleum engineer for the purpose, pardon me, reservoir engineer or petroleum engineer?
Both. He's a petroleum engineer and a reservoir engineer. He's, yeah.
For those purposes, he is so admitted.
Thank you. I think I'm just going to give a brief opening statement to kind of frame where we're at with the board, because this particular matter has been kind of going on from an administrative standpoint in early December to now being in front of the board. So EP Energy drilled and completed and placed 2 wells on production back in late August 2018. That's the Duchesne City 1-25-26-C5-1H well and the Duchesne City 1-25-26-C5-2H well. For purposes of the hearing, I'll refer to them collectively as the 125 wells. It's just a little bit easier. But you know, we'll have the one. Mr. Biancardi may be referring to them separately as the 1H and the 2H. These are EP Energy's first horizontal wells in this basin. And they're 2-milers and they're both in a 1,280 acre spacing unit. They were both selected for rate transient analysis and other production tests so that EP can evaluate their well performance and be used in making their future Uinta Basin horizontal well plans. Prior to achieving production on these wells, EP's third-party gas gathering company installed a pipeline that all parties involved estimated would capture all of the natural gas from these wells. They're oil wells. They're not gas wells, so obviously they're oil wells, so it is co-produced natural gas. But by the time these were fully completed and placed on production, so we're talking early October, so a couple of weeks after they began production in earnest, it became clear that these were two really good wells, some of the best wells that EP's ever drilled in any basin anywhere. And because of that, we were going to far exceed EP Energy and the third-party gas gatherers' production projections and their ability to take our gas. There was just not going to be enough room to take our gas, for lack of a better way to put it. So we ended up having to begin flaring because we were doing these rate transient analysis tests, and obviously, when you're doing these type of tests, if you shut in or you choke back the well, you not only destroy the results of your test, but you could also damage the wellbore, and you can actually even damage the reservoir by doing that. And so we wanted to avoid that. So we immediately contacted the gas gathering company, told them what the issue was, requested that we have additional pipeline loop capacity be constructed, and provide us with all options we have to minimize, reduce, or prevent flaring from these wells until they could do that. During the next several weeks, they were able to make changes to surface facilities, the existing pipeline that would increase the takeaway capacity. And so the first thing that happened then, and this happened in late in November, we were able to stop flaring from one of the 2 wells, but not from the second well. And so we continued to take these steps, but we realized that, there was going to be no guarantee that we would not be flaring from one or the other of the wells until the pipeline loop was completed. And the gas gatherer is telling us that's in April of 2019. So in early December, in order to not be flaring gas outside of the rules, EP Energy submitted sundry notices to the division for both of the 125 wells, requesting administrative exceptions to the flaring requirements under R641-3-20, and basically to give us enough time so that we could put together and file our request for agency action for a flaring exception that would extend until the pipeline loop was built. And so that exception was granted, was administratively granted in the middle of December, and it allowed us to flare natural gas in excess of the quantities under 641.3-20 through January 27th. So now on January 10th, we filed our request for agency action, and that was set for the hearing today. The problem is that we obviously had an administrative exception that only went to January 27th and a hearing on February 27th, so we had to do something. So we filed a request, a motion for an emergency order that would extend that flaring exception from January 27th to January 30th, last month's hearing. We appeared at last month's hearing and provided the board with testimony and evidence and from Mr. Biancardi, the same witness that's here today, and established at that point that since we had filed our emergency order request on our RAA, the gas gatherer told us that, oh, by the way, you know, the pipeline is a high-pressure pipeline being run at low pressure. And so immediately Mr. Biancardi and EP were like, compressor anyone? So we put a compressor on it, and that allowed us to basically stop flaring gas prior to last month's hearing. However, their machines, they break down. We're not going to have a guarantee of no flare until we have that pipeline loop put in place. And so what we're here for today is we have a flaring exception through today under the emergency order and the limited order that the board granted. And we're asking today under our request for agency action to have that exception further extended until the pipeline loop is finished in April. You know, importantly, little has changed with respect to these wells since the board last heard from us. We are not flaring from either of these wells, except in, I don't necessarily know if you want to call it an emergency situation, but you have a part break in the compressor, you need to shut it down for 2.5 hours or something along those lines to fix the part. You may be flaring during that period. God forbid something happens with the compressor as a whole and it needs to be replaced or something, because I believe it's just skidded out there. You know, that might take a couple of days. EP is not wanting to play fast and loose here. They want to make sure that they have the exceptions required and that the board is aware of what's going on with these wells until they get that guaranteed no flare pipeline in place in April. So again, we're here today to just ask for an extension until April. Mr. Biancardi is going to give testimony. We have some exhibits. Obviously, these were filed on January 28th, which was actually 2 days before last month's hearing. And so these were prepared at a time when we didn't have no knowledge of the compressor and stuff. And so Mr. Biancardi is going to orally update any of the portions of these exhibits. There's not a lot. Most of it's still all good. But there's a couple of places where he would just want to tell you that we'll orally update. For example, one of the exhibits says, you know, we're flaring from one well but not the other. We would update that to say we're flaring from neither. There's other, and so before I get to Mr. Biancardi, there's two other important matters I'd just like to address, and that's EP Energy and the division and the board didn't receive any protest responses or other public comments regarding any of this process. It's administrative exceptions, it's emergency order, it's the interim order that's in place right now, or the RAA. And then lastly, in discussions with CITLA, I was requested to make a statement on the record that to reflect that CITLA does own interests inside of the 1280 DSU where the 125 wells are drilled. They didn't have any exception or anything. They just wanted it noted that they have an interest in the lands. And so with that, I'm going to go to Mr. Biancardi. He's already been sworn and qualified as an expert, so to move things along here, we are just going to go through, we'll go first through exhibits L1 to L4. Again, these are general locator exhibits, and this will be fact testimony as to where the wells are so that you guys understand where they are. And then we'll get into the engineering exhibits after that. So Mr. Biancardi, this is exhibit L1, and I'm assuming you're able to see that remotely. So if you could please confirm that you can see it remotely, and then describe what's depicted on exhibit L1.
Yes, I can see it. Exhibit L1 is a regional plat, it's a locator map for our wells, the Duchesne cities, 25, 26, and sections 25, C5 and 26, C5. It is in Duchesne County. It's basically in the middle of the map to the left side. You can see the unit outline there, showing the two sections, but it is a 1,280 acre unit.
Okay. I'll move on to Exhibit L2. And this is, again, we're just zooming in to the wells here from 30,000 feet. If you could please describe what is depicted on Exhibit L2.
Yes, this is just a zoomed in. This is an aerial view of the unit, sections 25 and 26 of C5, 3 South, 5 West. It shows and identifies the location of the Duchesne City's 1H and 2H wells there in the northeast corner of section 25. And the other wells that are within the unit. There's just to the south or southwest of the Duchesne City's well. There's just to the south. There's the Duchesne City 225C5. That's a vertical well that the Duchesne City's 1H and 2H wells. They extended that pad and drilled horizontally from that pad. There's a plug well, the Paulette Walker 25-7, just to the southwest. There is a producer well this is all in section 25. In the southeast corner of section 25, the Moon 325C5. Then there's a plugged well, the County Fee 1 to the west. And in section 26, there's a plugged well, the 126C5 in the north half of section 26. And there's a producing well in the southwest, I guess it'd be the southwest of the northwest, the right 226C5. And then lastly, there's a location, the 102635 BTR. So that was an APD. That well is not drilled.
Just because you've mentioned it, Mr. Moon, is this anything that you're involved with?
We don't have any mineral.
So let the record show.
Unfortunately, you would like them in this particular DSU.
Two biggest wells in their history. Just for the record, Mr. Moon does not have a conflict of interest for this matter. Proceed.
So, Mr. Biancardi, I guess this is a good time, once, given that we've got this map up here, can you please describe to whom notice of the RIA was given, and confirm that EP Energy has received no protest or response or other comment from any owners or other third parties regarding its RIA?
Yeah, so we gave notice to all the working interest owners and royalty owners in this unit, and we did not receive any protests from any parties.
Now we're going to move on to exhibits L3 and L4. Given the zoom here, I don't know if the board's going to be able to notice a big difference. These are stacked wells, so they're right on top of each other. So what I'm going to do before he comments is I'm just going to show the board both of those exhibits, L3 and L4, and then ask him to comment on both at the same time because they are substantially similar. So this is the 1H Duchesne City well, and it's the plot showing all the, where the well's located, where the surface location is, and where the heel and toe and boundary line setbacks are. And then Exhibit L4, as you can see, I'm switching back and forth between them, and the only thing you can see moves is the 2 and the 1 in the corner. They're right on top of each other. So if the board wants me to pick one or the other, I'll leave it on L3. And Mr. Biancardi, if you can please describe what Exhibits L3 and L4 are depicting with respect to the 125 wells.
Yes, this is the location plat for the 125 wells. It depicts the plan path of the well bores. Basically, both wells, it's a stacked lateral separated, but the two stacks are separated by approximately 260 feet. And going from the northeast side of section 25 to the to the northwest corner of section 26, all along the northern edge of the unit boundary. The 1H well we ran into some drilling problems with the 1H well. It actually ended up being drilling short, so it didn't make it to the 330-foot line from the west unit boundary. It was 1,424 feet, but the 2H well did make its full lateral length. Essentially they're the same, except for the 1H well was drilled a little bit short.
Okay. And I'll just switch over to L4. And I don't think there's anything on this that's much different from that. But if there is anything, go ahead and comment on it.
It's essentially the same, of course. And again, this well was drilled to its full lateral length.
So moving on, we'll get into the engineering exhibits. And as I had given the board a little bit of foreshadowing here, I'd like you to walk the board through Exhibit E1, but paying specific attention to the identification and correction of any statements in here that need updating or that are no longer correct or that have changed in any way.
Okay. I'll just go through each of these bullets again. The Duchesne City's 125-26C5 1H well and 2H well were drilled and completed in August 2018. These, again, as Mr. Chicken stated, these are the first horizontal wells in Uinta Basin that was drilled by EP Energy, and these are two of the most productive wells. The 2H well is the most productive well that we drilled, and then the 1H well is in the top 6%. So we're very pleased with the results of these wells. In October 2018, as Mr. Chicken mentioned, gas production from the 125 wells exceeded expectation. The capacity of the 125 wells pipeline causing us to flare. And I have on exhibits E3, E4, and E5. I have some production plots, which I think I'll be able to show what occurred and kind of the anomaly that we ran into that we didn't expect, and which caused us to exceed the capacity of the lines that were put in place. But once that did occur in the middle of October, we did contact our third-party gas gathering company, and we're looking for every option that we could to reduce and or eliminate the flare. We were able to get the 1H well online and selling, but the 2H well it exceeded the capacity of the line. We did need, we're very interested in the performance of these wells because we're trying to evaluate these wells so that we can then continue on with our horizontal development program. The Duchesne City 125-26C 51H well, we had to install artificial lift on that well, and we did that in December 16th of 2018. And the Duchesne City's 125-26C 52H well, it was flowing up casing and started loading up a little bit, so we ran a packer and tubing to help with the production of that well, and it is still flowing. One thing that we did do on January 24th is that we're looking for all options to eliminate the flare because that was not a satisfactory situation for us. And then after working with the gas gathering company, we were flowing into a low pressure line. That low pressure line was evaluated and determined to take gas at a higher pressure. So we then made plans to install or get a compressor on location so that we can then compress the gas, which we did that on January 24th, and on January 30th, actually the date that we had our hearing, we had a couple of startup issues, but we got those lined out. And except for one problem on January 31st, we've really been the compressor's been running without any hiccups or without any problems, except for we're down one and a half hours in February. But so in February we virtually had no flaring, and so we're able to eliminate our flare, and we're very happy about that. We didn't want to shut in and choke back the wells because we are evaluating the performance of these wells. We're also concerned about the damage to the reservoir, so to the well bore. This wax, the oil is a very waxy crude. In fact, we have to heat it to 160 degrees. The pour point of the oil, meaning that the temperature which it'll set up is at 105 and 120 degrees. So it has to be kept hot. So if you were to shut in the well, you would actually basically wax up the well bore, but that would be costly to clean out. But then also there's concern about the shutting in the well and what that might do to the reservoir or the ability of the reservoir fluids to be able to flow through that reservoir. So we're concerned about waste, and we're also wanting to continue producing the wells so that we can evaluate the performance and evaluate our frac design and set up our frac designs for future wells. And then, as I mentioned, currently we are virtually all the gas that's being produced out of the 125 wells, both the 1H well and the 2H well, is now going into the pipeline. And the only time that we've flared is when we had maybe a problem with, when we had a problem with the compressor, we had one lasted about an hour. We had a little bit of a problem with the suction control valve. That was fixed, and we haven't had a problem since. So that's kind of where we are right now. Both wells are producing, flowing into the pipeline without a flare. And again, as stated, we do have future development plans. We do have some additional locations in this unit, section 2526 of C5. We also have over 159,000 net mineral acres in the Uinta Basin that we have spaced over in 2018 and three spacing hearings that we can then continue with our horizontal development program. And then as it stands right now, we have one rig drilling in the field, and they are drilling horizontal. It is drilling horizontal wells, dedicated horizontal wells. We have 2 wells that are waiting on completion, and currently we're drilling a 3-well pad. And as stated, we needed, not only were we concerned about damage to the reservoir and damage to the well bore, we're also taking the production information that we can get from the Duchesne Cities 1H and 2H to help us evaluate the performance of the reservoir and also our frac design.
We'll move on to Exhibit E2, which kind of describes some of the background with the pipeline itself, the alternative uses for the gas to flaring that we've identified. And if you could just describe both of those areas and then make sure that you update and/or correct any statements that have gotten stale because of the timing.
Okay. Again, as stated earlier, as far as the pipeline is concerned, we exceeded the capacity of the pipeline in October, and we had to go to flare. And at that time, I had to say, both EP Energy and the gas gathering company started looking for anything that they could do to relieve the restrictions or remove restrictions in the pipeline that may be creating some additional back pressure. And we did. Some back pressure valves were removed. Any other chokes or items within the pipeline itself that would create additional back pressure. But while we're doing that, they also determined that the maximum allowable operating pressure of the pipeline was 270 pounds. It's a low pressure line rated, which they like to run at 65 pounds, but they could take up to 270 pounds, and that allowed us to install the compressor, and we're now injecting into that line at about 140 pounds. So the correction here is that the modifications had largely reduced flaring of natural gas in the 125 wells. I would say it's virtually eliminated the gas, and the only time we're flaring now is in the event that we have a problem with the compressor. And then that'll be in place until the pipeline loop has been completed, and that is currently in progress. So the gas gathering company started working on that as soon as we notified them that we're having problems with met the capacity of the line, and that completion date is still set for April 1st. So we're a little over a month away of that line being in place.
And so
we're pretty. Go ahead.
I just wanted, before you move on to the alternative uses, I just wanted you to confirm for the board that, because you virtually eliminated flaring, you're not flaring now, the relief that you're seeking today is going to be relief that you hope to not have to use.
Absolutely. We hope we don't have to use it at all. But as you mentioned, if we happen to have right now, our alternative measure is running through this compressor, and if we happen to have problems with the compressor, then we would need to go to flare if that were to occur before the pipeline was in place. But hopefully, and we believe that it won't be necessary, and this is more of an insurance for us. And as we want to be in compliance. And hope, like other insurance policies, you hope we never use them. So that's where we are today.
Just for clarification, when you say loop, how does that vary or differ from twinning the line?
Actually, looping and twinning are very similar. There is a map that shows you where the path of the light of the pipeline. Part of that is a loop. It's actually Exhibit E6. But part of it is a loop, part of it is a new line, and then there's it's quite an effort to bring this additional gas capacity to that well. But
Okay.
Yes, part of it is looping and twinning is essentially the same.
Okay, and then third-party gas gathering entity, is that Kinder Morgan?
Yes, sir, it is.
Okay, thank you.
And I'll prompt you when we get to Exhibit 6 to kind of go back to the chairman's looping versus twinning question. Let's move on to Exhibit E3, which breaks down the monthly production as we were able to provide it through December 2018 when we filed these back in January. But please update the board accordingly. Particularly, I don't think they need every single number, but definitely the January numbers for gas flared and whatnot.
Yes. Okay. This is just a report of the production from the 1H well and the 2H well, just to orient you with the report. This is at the time of the submitting our exhibits. We had monthly production through December. So just through December, we had produced have the oil production, the water production, the gas production, the gas oil ratio, which is it's kind of an interesting indicator of some of the issues that we ran into, and I'll point that out as I get to it. Then our gas sales, and then of course the difference between production and sales is the amount of gas that we flared. So you can see on the 1H well, we only flared, we didn't really on the 1H and the 2H, we didn't flare in August and September. We ran into some capacity issues in October. And on the 1H well, we had a little bit of flaring in October and not a full month, but a partial flaring in November. And then, and that was it, because the 1H well was able to go into the line. And then, so in December, we didn't have any flaring at all. So through December, we had flared 20,561 cubic feet of gas out of the 1H well. That's the column to the right of the 1H well.
Mr. Biancardi, that's total flaring between August and December, which is really only for 2 months, was 20 million.
That's right.
Thank you.
That's right.
Thank you.
From that well. Yes, sir. We did produce 86,000 barrels of oil. We did produce 156 million cubic feet of gas. Did sell 136 million, but we had to flare 20 million. So on the 2H well, again, which is the same information as oil, water, gas production, the gas oil ratio. Let me back up if I can, and I have it. You'll see this more on the slides, but on the gas oil ratio column on the 1H well, you see it started at 7, got to around 1,000, 1,100, 1,131. That's about where we expected it to be, and then it gradually increases over time as you produce. And that gas oil ratio of 2,700 standard cubic feet per barrel is what we're expecting to see. And then you'll see on the 2H that is significantly different. But again, so going to the 2H well, we didn't flare any gas in August and September. Again, we ran into some problems in the middle of October. But you can see that's when we started to see a pretty rapid increase in the gas oil ratio, and that carried into, which went from 1,500 to 3382 to 5946. So that is just a lot more gas relative to the oil production that had anticipated, because it's anomalous to offsets. But so we started flaring gas in October. And we ended up flaring. We produced roughly 47,000 barrels of oil, 70 million cubic feet of gas. Had gas sales of 45 million, so we flared roughly 25.6 million. And then in November, we produced about 40,000 barrels of oil, 134,000 cubic feet of gas, and we ended up had sales of only 20 million because we basically couldn't move any more into the pipeline, and we ended up flaring 113 million. And then in December, virtually all of our gas, we did produce 24,000 barrels, but virtually all the gas that we produced had ended up going to flare. So I do have, so that's the story, and I also have plots in exhibits E4 and E5 of the performance of those two wells. But I do have the January numbers now. But if it's okay, I can just tell you how much was flared from the 1H well in January and how much we flared in the 2H well. So I'll continue with that. So in the 1H well, we didn't flare any gas at all in December, but recall in January we did install that compressor, and we tied the two wells in because now both the 1H well and the 2H well would be going into a higher pressure, and the 1H well might get knocked offline. So, and we had a few problems from January 24th actually through January 31st, and so we ended up having to flare on the 1H well about 3,072 MCF of gas, 3,072 on that well. Just a little bit of flaring, and then from that well, all that's associated with the startup of the compressor, and again, we haven't had haven't had any flaring in February since. On the 2H well, we flared 69,040 MCF, which is down significantly from the 145 that we had in December, and that's associated with the startup. And we also did some well work on the well, so we reduced the flare in January significantly, and we haven't had virtually any flaring at all in February. It's only like I said, we were down an hour and a half. In February, we flared a total of 114 MCF, 29 MCF from the 1H well, and 85 MCF from the 2H well in February. We've had sales from both those wells since.
So I just want to confirm that. So by the beginning of February, compression is in place, and you flared 114 MCF from both wells combined in the month of February to date.
That's right. Right. That was February 6th. We had a little bit of a problem on the suction control valve that was easily fixed. There's a little bit of adjustment on that. Essentially, what happened was that the control valve closed in on the well, and the compressor has safety systems in place, and it sensed a low suction, which was out of the range of what it was designed or set to operate in. So it just killed the compressor. And but it was an easy fix. It was an adjustment to that suction control valve, and put right back online. So it really wasn't an issue with any major concern. There was just a little bit of a malfunction of that control valve that actually pinched off the gas to the compressor, and the compressor shut down. But yes, 114 MCF, it was February, and that's been producing ever since, and selling gas ever since.
Thank you, Mr. Biancardi, and I'm just going to ask you to confirm that what you just described is a good example of the reason EP believes it still needs this flaring exception until the permanent permanent fix of the pipeline loop is put in place, correct?
Yes, sir, that's correct. It is, as you mentioned, and as you testified in January, it is a machine, and it can have, it's relying on all the components of that, working as it's designed. So that's why we're asking for this flare. I want to extend the flare permit until we get the pipeline in place, because we want to make sure we're in compliance if in fact we do have another event.
Okay, thank you.
That's really good runtime on that compressor.
Thank you. We'll move on through exhibits E4 now, which shows, and I think E5. These are very similar to the L1 and the L2. These are the two production plots. So if you could start with E4 and just basically describe what is depicted on there, what each of those different colored lines means in relation to the production plotting.
Yes. Okay, so just going from the top of the production plot down, the green line, that's our oil production. The red line is the gas production. Dropping down to the blue line, that's our water production, and then this kind of a purple or dark red line, that's the gas oil ratio, and that is you can see in this plot towards the end of January, we're running about somewhere between 2,000 and 3,000, about 2,500 MCF per barrel, and then 2,500 MCF per barrel, and then standard cubic feet per barrel, and then the light blue line below that is just a water oil ratio. So we monitor we monitor the production, but we also take a really good eye on these ratios, because they tend to tell you, more what's going on with the reservoir and how the reservoir is performing and what it's drawing from. But you can see on the 1H well towards the end of January, and then so then after that there's a projection line that we have for the oil and the gas, and actually the gas oil ratio, and just tell you that so the number 1H well towards the end of January was producing just over 300 barrels a day, just over 400 barrels a day, and it is currently producing pretty much on its projection line. Along with the gas, it's just over 1 million cubic feet of gas a day, and it's actually slightly above that, the projection line. The water production is a little over 800 barrels a day, and that's about where we are now. And then the gas oil ratio was 2,500, as I mentioned earlier. It's about 3.1 now. We're producing a little more gas relative to the oil production, but the water oil ratio is about the same. And to the left and to the right of the charts, it's probably difficult to see. It's just the scale of what we have there. But that's the we monitor the oil, the gas, and the water production, and then we take particular interest or attention, to these ratios. I will tell you, in December, that's when that downtime there was when the ESP was installed. And again, lastly, on the gas oil ratio, and this will be more evident in the next slide, the gas oil ratio that we're seeing here is as expected, and so it's really not out of the norm, you might say, for the gas production from this well.
Can I interrupt for a second, just so I understand? I can't read the scale on the left side. So take the, what is the IP on this well?
It's just over, excuse me, actually I've got that.
And then it grew to?
Yeah. It's in the, well, as far as the best rate is 967 barrels. That's the, okay, so just going over to the scale, where the oil production is just hitting that top line, that's 1,000 barrels a day.
That's
just dropping down.
That's 1,000 barrels a day?
Yes, sir, that's 1,000 barrels a day. So you're seeing we're just skimming right on that. Okay. For the gas, that's right at 1,000, coming down the scale on that. That's 1,000 cubic feet a day.
Standard cubic feet?
A day. That's 1 million a day for the red, excuse me.
Is it MCF or standard cubic feet?
That's 1,000 MCF, or that's 1 million cubic feet of gas a day. It's about a 1-to-1 ratio when we first started.
Okay, thank you.
And then the water is, so the well came on the water. If you just drop down, that scale is a little over 2,000 barrels, coming down to 1,000. But a lot of that is load water, so from the frac. And actually, if you go down to the water oil ratio line, this is you see the water oil ratio, which is the light blue line. We see that drop down. Actually, what that is this: you're picking up a lot of the load water that's being produced out of the well, and then that's why that trends down. So then when it floors out, it's flooring out as far as to a little bit under 100 barrels a day on water. That's really more from the reservoir. And then so you've kind of recovered your load water, and then it picks back up, as you see, going up to about 200.
Okay, one more question, and then I'll let you continue. How does this graph differ from a decline curve? Or is this a decline curve, but it's basically too short a period?
I'm sorry, could you repeat that?
It's a decline curve plus.
It is a decline curve plot, but too short a period to show the decline rate?
Yeah, well, we have a decline. Yes, it's not the full life of the reservoir or full life of the well. It's just focused in on this period of time of this well. Yes, sir.
Okay. Yeah. Thank you. That answers
but it is the decline. It's the decline curve of oil, gas, and water. But then again, we pay a particular attention to the ratios.
Great. And so instead of Mr. Biancardi, instead of looking at the entire life of the well, say over 30 years, this is taking a snapshot of the well so that you can actually focus in on specific days between August 2018 and today.
That's correct. That's right.
And then on the left-hand side, the color coding shows you that, and for the board's edification, I'm using the pointer over here. The color coding is really important because this line is a different line for water, oil, or gas, right? Depending on the color
Yes.
code. So if you're looking
Right.
at gas, this is 100 barrels, or I mean, if you're looking at oil, this is 100 barrels of oil, but it's 1,000 MCF as well. So that's all I wanted to point out. And let's move on to Exhibit E5.
Okay.
We'll move on to Exhibit E5, and you can kind of just, I think they understand, the board understands all of the color coding and what this is, but if you can just
Right.
contrast this well from the other well.
Okay, so this again, this is this is the production plot for the same time period of the 2H well. And you can see this well came on at over 1,000 barrels a day. We had I think the 1681 was the max rate on this well. You can see it's above the just underneath the 2,000 barrel per day line, in between the 1,000 and 2,000 barrel per day line. You see they held that rate over 1,000 barrels a day for really over 3 months, and then it dropped down to 1,000 barrels a day in the month of December, and then declined from there. The short shut-in period in January is when we tubed up the well. And then you can see on the gas oil ratio is producing over 1 million a day. Again, it's producing about 1,000 to 1 gas oil ratio, which you can see that's that purple line down towards the bottom. You see that's running right above 1 or 1,000, which is what we expected. That's actually the solution gas of the reservoir. But then you can see that it sharply rose beginning in middle of October and actually didn't plateau out until into December. And that's really what got us into trouble. We weren't expecting that with compared to the decline of the oil. But if you go to that purple dark red line, you can see where the gas oil ratio jumped, really rapidly increased from over 1,000 standard cubic feet per barrel to about 8,000, 7,000 to 8,000. So that's really that's what got us into trouble with the gas volumes. We're happy to see the gas volumes. We just weren't prepared for that, because normally you see that ramp up to about 2 to 2.5, maybe 3, but not as high as it got there. And that's really what helped us or caused us to exceed the capacity of the line. Now, then we have the oil and the water oil ratio. You can see this well, actually a very dry well, had a quick recovery of the water and stayed at a very low water oil ratio. So we're seeing two things. One, this is a pretty dry reservoir with the amount of water that's in it. But we're also seeing that because we're seeing this rapid increase in the gas, it's actually highly fractured. So actually existence of both induced fractures and significant natural fractures, which so the permeability of the reservoir is extremely high, and it enables the reduction of the reservoir pressure in that natural fractured area, which essentially what's happened, we're real close to the bubble point, which is the point at which gas breaks out of solution in the oil. And since we're able to do that so rapidly and so effectively, that's where this gas broke out of solution. Great. So it's an indication of, we're seeing two things. We're seeing why we're producing over between 1,000 and 2,000 barrels a day, and then we're seeing a further indication of very good perms or natural fractures from this increase in the gas oil ratio. Okay. So that's what got us into trouble, and that was not expected.
Thank you, Mr. Biancardi.
The gas production.
Thank you. We'll just move on to Exhibit E6. If you could please describe what's depicted on here. There's a lot of stuff going on, and update it to current. And while you're doing that, address Chairman Gill's loop versus twinning of a pipeline question.
Okay, so at the very bottom, this is a depiction of the pipeline loop, where this is the line that's being installed and expected to be online on April 1st. The star is the location of the Duchesne City's 1 and 2H wells. You can see that there's basically, you can see the endpoints. The Duchesne City 2H was drilled to its full length, and the 1H was a little bit short. So you can see that a little bit left of the star. And then there is if you can look closely, if you can see it on the screen, there's a blue line that goes up to basically one section up and then it turns over to the right. And then let me back up a little bit. The other dots here are all the other, let me back up a couple steps. Okay, the blue lines is the low pressure gathering system that's in the field. You can see this, they kind of spider out to connecting to all the existing wells, which are the little purple dots. You can see that's where they're all tied in. And then the red line, if you go to the left of the exhibit, the red line is a high pressure line that Kinder Morgan has, a third party gas gathering company. And that goes all the way up to, that actually leaves one compressor station from the far southwest, goes all the way up to what is called the west compressor station. And then that's then boosted and then eventually goes to the third party's processing plant to the north and to the east. So so largely it's a low pressure gathering line with some high pressure lines in between that feed that. So the loop or the twinning of the low pressure line will be about it's really a little bit, it's about a mile, maybe a little bit more than a mile. You can see it parallels that blue line. This is the red is the new line, by the way. Yes, sir, that's it. Yeah, so that parallels the new line, but then you can see that there's an extension. It goes straight north. That's actually so the looping or twinning is up until just a little bit north, and then there's about a 2-mile extension up until this east-west line, and that'll be a new line. So you have a loop and a new line being installed, and that's a 10-inch line. And then there's a blue line that goes to the west. That's going to be an extension. It's about a 3,000-foot tie-in west to this. It's another low-pressure line right now, but that low-pressure line, which it's kind of a pink line on the map, that parallels and goes up to this west compressor station. So the steps here are they will be looping the low pressure line, building a new line, putting an extension, jumping over 3,000 feet west to this other low pressure line that takes us to the compressor station farther to the west, or the west compressor station. And then once all of that is complete, that will operate at low pressure, and then that is all being set to run at high pressure. So once all this is done and they get the low pressure operation in place, they'll test it for high pressure, and eventually that whole system will go to high pressure. And then once it goes to high pressure, the capacity of this line is initially rated for 3,000 or 3 million cubic feet of gas. It'll go to 10 million cubic feet of gas when we swing to high pressure. So that'll give us quite a bit more additional capacity for not only the Duchesne City wells, but they're also, we have 2 wells waiting on completion just north of Duchesne Cities, and then we have some plans for future development. So that'll add a lot to our ability to move gas out of this field.
Okay, thank you. And I think we have 2 more slides. E7 is an exhibit dealing with the results and what EP is learning from its rate transient analysis tests. If you could please describe what's depicted on here, what all the different color coding is, so that the board understands very well what they're looking at.
Okay. So this is in our RAA, we did mention that not only do we not want to shut in the wells due to concern for damaging the reservoir and the well bore, but we're also doing a production analysis. It's called rate transient analysis, basically taking the production from the well and the flow and pressures of the well and trying to discern from that, what the reservoir properties, what the perm is. Actually, we're evaluating for fracture half lengths, and then just seeing, drainage areas and things of that. So this is just one of many type curves that are being generated from the performance of the well. And again, instead of just being rate over time or a decline curve, which is just your rate over time, this takes into account the pressure, the flowing pressures of the well, and also the cumulative production over rate to kind of normalize the chart out a little bit. But again, this is helping us. It basically it starts giving us impulse or pulses from the reservoir. So the longer you produce the well, the farther out in the reservoir you're able to reach, and then you're getting signals back really from the flowing pressures and the rates that we then evaluate. So you can see that and then what you end up doing is it's a little bit different charting. So you take the charting, and this is kind of normalized rate over, it's called material balance time, but it's basically the normalized rate is just rate over the change in the pressure, and the material balance time is just a cumulative production over the rate to kind of normalize it a little bit. But you'll see that there's a change in the slope, and that's what we're looking for in evaluating both the fracture design and the transitioning into the matrix. And essentially to the left, and where it's a little bit shallower slope, that's a signal from the fracture. That actually, if you look at the red dots and then the blue dots that are on this, that kind of fit this orange line right here. Yeah. Yeah, so that is basically, it's early time, and we're getting a signal from the fracture and natural fractures, and these blue dots here is kind of a middle to a later time, and you can see the slope changes, which tells us that we're moving out of one regime, let's say the fractures and natural fractures, and into another regime. It's actually, it's a transitioning into the matrix. But we're taking this data, and again, the longer you produce the well, the more information you get from the reservoir. So that's why we didn't want to shut it in, because we can take this information along with several other type curves, and we're putting it into a reservoir model to help us understand some of the reservoir properties, some of the fracture frac design properties. And then this is still work in progress, but what we're seeing right now is kind of fracture half lengths of 150 feet to 335 feet, which is kind of right in line with what we expected to see. We're seeing a perm of 0.5 to greater than 1 microdarcy. And then again, we take this information, and it helps us see what we did, evaluate what we did, and then to try to move that forward to make sure that we have the right design moving forward. So it's really just trying to take as much information that we have from these 2 wells and applying it to the next wells that we're going to complete, and how it affects the rest of our drilling program.
Thank you. We'll move on to the final exhibit, Exhibit E8. This is a depiction of the long lateral, the 1280, the 2-mile horizontal well economics as both the planned cost and the reduced cost. And if you could please describe what you're showing here, particularly defining ROR, ROI, the strip prices used, that type of thing. Yes, sir.
Okay, so this is in this area, our type curve is still 640 MBO. That's based on some performance. This is over in the 3 South area, what we call C4, C5, 3 South, 4 West, 3 South, 5 West. And a lot of this type curve was derived from some of the activity from other operators to the east. It's a 640 MBO type curve. Have adjusted so that the type curve and to the longer life decline that we were discussing earlier is depicted in the graph up top. Also showing the gas production, and you can see it pretty well follows the oil line, except for there's a change in the slope, and that's really just we're trying to recognize this different gas oil ratio behavior. Which is happening rapidly. So for about a year, we're seeing a rise in the gas oil ratio. Then we're kind of holding that flat that parallels the oil production. But the point of this slide is really what we're trying. We have a planned cost of nearly $11 million to drill these wells, and we are very interested in taking the information from the first 2 wells that we've drilled and basically design a fit-for-purpose completion for the different targets that we have, and for the different targets, they have Wasatch targets and Uteland Butte targets. You might have a different design for the specific target in mind. In fact, in the Duchesne Cities 1 and 2, that was a Uteland Butte and a Wasatch test. So we're evaluating both and trying to come up with the right design for each. But since so last year when we had our 3 spacing applications, the oil pricing was much more robust, than it is now. So this was put together in early January, and you see that the strip price, which is at the very bottom of the slide, was 48.74 to 53.38, and then the gas at 2.79 to 2.69. Oil prices have come up a little bit, but I was looking at it yesterday around 55. But then directionally is still the same. So what we're trying to do is, in a lower price environment that we had last year, understand under plan pricing, what our economics might be. Probably better than what we're depicting here, because pricing is a little bit better now. And then if we could right size our completion, and maybe we don't want to over complete the well or under complete the well. So these are two extremes. So we could reduce the cost almost $2 million, depending upon the design, the wellbore design, and the frac design that we have. And that nearly $2 million reduction would increase our rate of return. It's just the same type curve. It's just a difference in the capital investment from a 24% to a 44%. And again, these are ranges. We'll probably be somewhere in between here, depending upon the design that we come up with. But I'm just trying to illustrate the importance of the evaluation of the Shane Cities 1 and 2 and its impact on our ability to continue drilling, which is what I very much want to do. So, but anyway, we're seeing an increase in the rate of return from 24% to 44% in this depiction, increase in basically a $2 million increase in net present value commensurate with the reduction in the cost savings. And the return on investment goes from 127 to 155, and it rapidly reduces the payout period. But basically, this the attempt here with this slide was to show you the importance and of the information that we're getting from the production decline and the evaluation of the production performance into what that causes us to do with the completion design, and what that could cause, or the result of that could be in improving our economics in a lower product price environment than we have today compared to where we were last year.
Thank you, Mr. Biancardi. So I don't have any further substantive questions or exhibits, so I'll ask if were exhibits L1 through L4 and exhibits E1 through E8 prepared by you or under your direction, supervision, and control?
Yes, they were. Again, on exhibits L1 through L4, I reviewed all these with our landman, and they're all true and correct.
Okay.
And then the others I generated. Yes, sir.
And do you believe the relief request in the RAA is going to minimize damage to the reservoir, protect correlative rights of owners in these wells, minimize waste, provide a greater degree of safety, and afford maximum recovery of the resource?
Yes, sir, I do.
I have no further questions for Mr. Biancardi.
Let's admit your exhibits at this time.
Okay. I would like to move that exhibits L1 through L4 and exhibits E1 to E8 be admitted to the record, subject to any objection from division or board counsel.
And R2.
Oh, I apologize. Yes, and R2, which is Mr. Biancardi's resume.
Division?
No objection.
Board members? They're so admitted. Thank you.
Thank you, Mr. Chair.
So we're at the end of your presentation in chief?
Yes, sir.
So we're now to the division?
Yes, we just have some questions for Ms. Biancardi. Mr. Biancardi, the real question here is whether or not you should be allowed to flare, and that generally goes to the cost comparison of the value of the oil and gas versus the costs of alternatives to flaring. And so I'd like to just focus on that very briefly. And I don't know if Exhibit E8 is helpful in that regard, but could you tell us the value of the gas and oil either in per day or per month from these two wells? Or from, I guess since we're just really talking about E2 is the only one that's currently flaring, but
well, actually, neither well is flaring right now.
Right, but the only one that isn't in a pipeline. However you want to answer that question, I'd just like to get ideas to the approximate value of the oil and gas as it's being produced. And then I'm going to ask you about the costs of alternatives to flaring.
Yeah, I don't have a run for the value of the oil and gas from these two wells, but we could look at, if you want to reference the maybe by proxy, the E8. This is a net present value of a type well at the oil pricing that I ran, and the net present value of that type well is about $3 million. If you use our capital cost to drill the 1H and 2H was right at $10.4 million, just a little bit under the capital cost in this plan at $10.993. Probably the average reserves between the two wells is going to be greater than the 640 MBO type curve that we have here. So I would say that just to try to answer your question, the net present value, if we were to experience this strip pricing, although we have production that's at a higher price earlier in the year, the value of that is $2.9 million. So it'd be north of $2.9 million on average per well.
Per year?
Probably. Excuse me?
Is that per year?
No, that's the full value of the well. The net present value, discounted. 100%. That is after investment.
That's not helping me compare the value of the gas to the cost of maybe.
Okay.
Let's go to the compressor first. Then, what does it cost to run the compressor per month, or I guess you rent the compressor? Is that?
Yeah, I don't have the rental. I'm sorry, I don't have the rental rate on the compressor. I know that we spent $68,000 to install the compressor. So we did do that, and there really, other than shutting in the well, there really weren't any other viable alternatives that would be available to us in the period of time that we're looking at. If we didn't have the compressor, we would be flaring and then waiting for that pipeline to be in place or to be installed. These other alternatives would have a much longer lead time than the pipeline itself would have. And if we were to shut in the well, then you run risk to the reservoir and to the wellbore itself. So there really wasn't a viable alternative, and we're thankful that we could get to looking for other alternatives before the pipeline was in place. We're able to install this compressor.
So can I ask, why did EP not know that the pipeline was a high pressure line operating at low pressure and available when you filed your application?
Yes, I can answer that. It's not our line. It's a third party's line, and it is a low pressure line. That the operating pressure of that line is typically around 65 to 70 pounds. All right. When we were looking for alternatives, we reached out to the gathering company, and then they evaluated the line, and they said that the maximum allowable operating pressure of the line is 270. Up until then, and virtually all of our production going into their gathering lines is around a 65-pound line pressure. So it's not our line, and it wasn't until we were having conversations with the gathering company to this is what your line is your normal operating pressure line is, what could it go to? And then that's where they informed us after their evaluation that which they you want to make sure you're operating safely. Is 270 pounds. So then once we became aware of that, then we looked at sourcing a compressor that we can then take this low pressure operation that we have and run it at a higher pressure. Okay. So it's just a matter of having a problem and then looking to find solutions to the problem.
Could you show us on the map E6 what part of the pipeline was on low pressure? And
yes, on E6 all of the blue, basically the gathering system is run at low pressure, and that is all of the blue lines that basically connect all the vertical well, or all the well bores, vertical and now horizontal, to the gathering system. Those then basically go to compressor stations that then boost that gas from a low pressure gathering to high pressure. So the blue lines are all on average operating at about 65 pounds. You can see that's really every single well is connected with a low pressure line. It's a low pressure gathering system.
So could you just
it
show?
Only goes, I'm
so
sorry.
What's the pipeline that you didn't know that was available at high pressure that now you find out is available? Could you just trace that?
Yeah. So on the cursor, it's still a blue line, right? It's still a low pressure line. It's just they're just now allowing us to operate into that line at higher pressures because they've evaluated that. And yes, Mr. Chicken, I think, is running the mouse over that. There is a blue line that parallels the new red line, actually up until it tees over and goes to the right.
I'm gonna see if I can zoom in a little bit more and get it's right on top of the other one, so it's really kind of hard to see.
Yeah.
I don't know if we can get the zoom for it, but there's you can kind of see it. There it is, right there. That little one right there is low pressure, but could be run at high.
So, and I don't mean to ask stupid, questions that are wasting your time, but I'm just, because it's taken care of, but does that mean that all those other blue lines that are shown on that map, if we had a well that was flaring, could be stepped up to high pressure?
It's not our line, but I would say that I don't know if you can make that a blanket statement. I know that the gathering company evaluated the flow path of that line and determined that part of their gathering system had pipe that was available to take gas at a higher pressure than the 65 to 70 pounds that they like to operate it at. So again, it's not our line, but I don't think it's a blanket statement that that entire system could be operated at a higher pressure than they're operating it at. That's I don't think that's their intent. If you increase that part of the lateral is there's a little bit of a bottleneck. Just as you go to the east, it opens up. The bottleneck opens up. If you follow that, Brent, can you zoom in a little bit again?
Sure.
Would that be possible?
Absolutely. Which part? Well,
just right back to where we were before.
Sorry.
I just want to show you that.
See if I can get back down there. There you go.
Yep. Okay, right there. So see where that low pressure gathering line turns over. If you just go north from there, and then I'll just tell you when to stop. Okay, about right there. There's to the east of that junction, there is I don't have the pipeline IDs, but I think it's a bigger line, and the bottleneck is right there, and then that may be a bigger line. So we're able to operate at that section of the line at a higher pressure from the Duchesne cities to that point. And which basically they evaluated that part of the line to see if it can handle higher pressure. It's a still low pressure gathering system that they've determined can handle higher pressure, which is what they're enabling us to do, so we can shut off the flare.
Do you pay a higher price per cubic foot for transferring that, or per whatever unit you pay to use it?
I think I don't think I'm able to answer that question. I don't believe so, but I'm not in our gas marketing group. I think this is a situation where it's beneficial to both parties. By us being able to inject into that line at a higher pressure, it eliminates the flare. And we do have a contract pressure that with the gathering company that they would keep their low pressure gathering system at. And we're above that contract pressure, so it's, we're agreeing to be above that contract pressure, which is taking the onus off of the gathering company to keep that pressure low so that we can then operate at a higher pressure and eliminate the flares. So basically both companies are working together to solve this problem.
So it's pretty apparent that it's economically advantageous to use the compressor because of the amount of gas and oil that are being produced from this well. It would be helpful to the division to advise the board in the future to know what it costs for the compressor and what it costs to, so we know what the break even is if somebody else says, well, we got a flare because we can't use a compressor. Could you provide that information to the board?
What it costs to, yes, sir, I can. What it costs us to operate the compressor, the installation, and the monthly
and any additional costs that are associated with using the line.
Mr. Biancardi, let me emphasize what Mr. Alder is saying. We have a statutory requirement that if we're going to flare a certain threshold or certain standards have to be met. And,
yes, sir.
And Mr. Alder is trying to help you meet that standard, but he still needs additional information.
Okay, so, I understand. I understand. Yeah, we looked at that as the alternatives to flaring and one shutting in the reservoir or shutting in the wells was we're very concerned about damage to the reservoir and to the well bore, and the alternatives we had were then as we depicted in. I understand the question, but as we depicted, we were looking at electrical generation or gas reinjection, both of which are, the lead time on that would be well beyond the expected installation date of the pipeline itself, of April 1st. So our options were limited there, and actually this compressor is kind of a temporary solution to that problem. But I can certainly I do understand the question. I can get the cost of the compression. I can get the cost of the rental, and then I'll find out if there's any additional cost to run this at a higher pressure from the gathering line. Yes, sir.
That's all the questions the division has. Thank you.
Board members? Okay, Mr. Brown.
My question's very much akin to Mr. Alder's, Mr. Biancardi. Given the critical nature of the compressor, what kind of spare parts or critical lead time items do you or the service company maintain so that these things can be quickly repaired? What is the longest lead time item that could fail? You've mentioned valves. You've talked about a catastrophic compressor failure potentially. Could you address that for us, please?
Well, I'm not in the production department, so I don't know if I'm able to answer that question with all the information. But I would think that I could hazard a guess if you like, but I know that it took there's a lead time of getting a compressor, so if we had a complete compressor failure, that would have a longer lead time. I can't tell you what that lead time would be. But if we had, if valves and things of that nature, those are probably more readily available. But I don't think I'm able to answer specific lead time questions. I would like to, but I just don't think that I can because I don't have that knowledge. I do know that, then if we were to have a failure that we couldn't repair, then our solution would be to have to go to flare. And then again, we are looking for that pipeline to be in place on April 1st. So we're looking at a little over a month for that.
I can appreciate maybe you can't answer those questions, but I know in my business we were always focused on an analysis around what critical spares we needed. Do you need a redundant system? Would another compressor on site be worth having? And maybe you could tell us that as part of the analysis that you're going to do for Mr. Alder and the board. I know you're getting close to the time now where this is moot. But again, that's something that I think you should consider when your opportunity here, I mean, for a compressor to fail, could be eliminated if you had another one on site. At least your lead times might be minimized.
Okay. I'll see what the lead time is for a second compressor if we had. Basically, that would be the extreme if the compressor failed and we were looking for another one. I will ask and find that out.
Thank
and
you.
report that back.
Other questions? Yes. Okay, over here on the left.
First of all, congratulations for drilling this well. That's wonderful. And congratulations for finding a solution so that this is largely talking about in an emergency you could flare. But I do have a couple of questions. You have one rig in the area that's currently drilling. If you put on another couple of wells that are as successful as this, are you going to exceed the capacity of that gas gathering line?
Where that well is drilling now, we have been told that we have the capacity. That section of that pipeline has the capacity to accept the gas that we expect to see. So I think that to answer your question, we believe yes, we do. On Exhibit E6, if you, Mr. Chicken, if you could go to that.
We're on it.
I don't see it. There you go. Okay.
Oh, that's E5.
Yeah, I need E6.
There's E6.
I was just going to go to, yes, sir. I was just going to go where the pipeline is.
Yep.
So where we're currently drilling now is over east of, actually it's in 2 South 4 West in section 25 and 26. And so if you were to zoom in.
We have to go up. Hang on, I'll zoom in and go up.
Okay, yep.
It's, they're way over here. There's 25 and 26, 2 South 4 West.
Right. Yep.
But you have.
So we're looking at, I don't know, have the exact, anyway, we're looking at tying into the system that's over there, and then we've been told that that part of the system has the capacity for the expected gas that we have. So, yeah, some parts of the field have more capacity than others, and according to the gathering company, and then over here we seem to be in pretty good shape.
You have drilled a couple wells just a mile north of these 2 wells that haven't been completed. Are you going to have capacity when those are finished?
Yes, sir, we will. If you, Mr. Chicken, if you can go back to where the Duchesne cities were, you can see those 2 wells. If you zoom in on that. Okay. Yeah, just to the north of Duchesne Cities 1 and 2, you can see 2 laterals. Those are 2 wells waiting on completion. And you can see those are going to be right adjacent to this new line that's being installed. So we feel like we'll have the capacity for those wells.
We're still with Susan for a minute, but okay.
On Exhibit E3, you show in December of 2018 on 2H, 145,221 MCF of gas flared. Was that below the allowed limit for that well?
Below the allowed.
Below the allowable limit. In other words, you're allowed to flare certain volumes of gas. Was that above?
Yes. Well, after we got the sundry, like I said, we talked to the division. We were there December 5th. We thought we actually had a flare permit in place, and we were misinformed. But we did get a flare permit, which gave us 6 million a day, and I think that's 4.7 on average. That's 4.7 million a day. So we were under the after we got the sundry, we were within compliance there. Yes, ma'am.
Thank you.
Okay, to you, Mr. Moon. Any more questions? Anyone else have some questions? I've got a couple. This is to you, Mr. Alder. Do you believe that the information you requested will satisfy all the statutory requirements for flaring, even if it's contingent flaring?
Yes, I think they probably have put on a case based on the information that's here, but that additional information will be helpful. Thank you.
Just for my education, is the factual information that the damage to the wellbore, damaged formation damage, if they were to cut back or do something else, would that meet that statutory requirement in your view?
I don't think we've ever looked at those costs or damages. We've just assumed that they were not acceptable and then looked at alternative ways of getting the gas to market or making use of the gas short of flaring. I don't know if that answers your question exactly, but in my experience, we've not put a dollar amount on reduced production from the well or damage to the well.
And I'm just concerned that we have met and checked off all of the statutory requirements.
I think we have. I did go through those as they were going through it. It's a little bit different because of the just one witness, but I think we've solved it. Thanks.
You think that if they provide you, if we approve this request for agency action today, and they were to provide, contingent upon providing you with whatever information you need to satisfy all those check marks, would we be wise to go forward with that, or should we hold this order in abeyance?
No, I don't think we need to hold the order in abeyance, and I would clarify that I'm certainly not the expert, but the division can look at those numbers and evaluate it, and I just think that the presentation needs to focus on that question, and having those numbers will allow us to do that. But I think it's pretty apparent that they solve that problem. They meet that standard, I guess I should say.
Okay. Any other questions? Any second thoughts? Then we're to the division.
I believe the division supports the request subject to the clarifications you've just made. Thank you.
Board members, we're to you now for any questions you have. Being none, we're back to you, Mr. Chicken, for summation.
I'm going to make summation really quick. I'm just going to ask the board to keep in mind that we are talking about 2 wells that haven't flared in excess of the rules without exception at any point in time. At any point in time, and they're not likely to. Going, as Mr. Biancardi testified, and I appreciate Board Member Brown's question. In the last 6 weeks, we did have a failure, and I believe Mr. Biancardi testified that failure was fixed in an hour, and we flared a combined 114 MCF to fix that. I can't tell you that that there will be another failure or that the other one wouldn't be bigger or smaller, but what I can tell you is that there's only a month left as far as we're sitting here, that we have to worry about that failure happening, particularly a catastrophic one where we would have to have a backup compressor on site ready to go. And then the other thing is I wanted to note as set forth in our RAA, if anything happens, and I'll make sure that this is in the order, but if anything happens between now and April where we're not going to have it by April, we'll file a sundry notice advising of that and explaining of that and copying that to the board. And if the board wants us to come and appear that month to explain what's going on or something like that, because again, on some level, it's not our system. We're not the gatherer. And if they call us in 2 weeks and say, you know what, we ran into a problem with this landowner, we don't have this easement, it's going to be June or something like that, we have no control over that. All we can do at that point is come to the board and say, hey, we still don't have this this permanent fix in place. And then lastly, on some of the costs and things like that, I think the bottom line here is that the compressor's in place. They have spent the money to implement the alternative that has eliminated flaring for all intents and purposes. And so the board's well aware of what we believe the wells are going to do. So we'll absolutely provide the additional information and let the division evaluate that information and report back to its council and or the board if they see any problems with that. But based on the fact that the relief we're asking for today is largely to cover an unforeseen emergency over the next month. We would request that the board, subject to the submission of the additional information, approve the request effective today so that we do not have a gap in our flaring exception until we get to the April 1st tie-in date. Thank you.
Okay, that ends the matter. Well, I think I can speak for the whole board in congratulating EP and you for such great wells. Keep up the good work.
I did not drill those wells.
Thank you,
Or
Mr.
the
Gill.
applicable department. We encourage you to drill more, and we'd like to see you back for not for flaring, but for more more drilling. And we appreciate the clarity of your exhibits. We do have a concern that we've met the statutory minimums. We think we have, but we're going to leave that to the division. So I think a motion would be in order, unless you'd like to talk about it. But the motion would be to approve the request for agency action, subject to the division's satisfaction that all the statutory requirements have been met.
So moved.
Is there a second to that?
Second.
Any discussion of that motion? Motion before you is to approve the request for agency action and the submittal of additional information to the division's satisfaction that the statutory requirements have been met. All in favor say aye. Aye. Any opposed? Let the record show that that passed unanimously. And I believe that concludes our regular business for today. And so a motion to adjourn is in order. And for the record, Mr. Chicken, will you prepare the order?
I will, Chairman Garrett. And Mr. Biancardi, thank you very much for your testimony today.
Okay, don't leave. And once we're off the record, I still have that follow-up question on the audio-visual.
Okay.
Oh, the motion before you?
Motion to adjourn.
Motion to adjourn. All in favor say aye. Aye. Any opposed? We are adjourned. Okay. We asked a question. Let's start with you, Mr. Biancardi. How did this work for you? Could you hear us? Could you see us? How did that go?
It worked very well. I have to give a lot of credit to your IT department, Paul, and I got with our IT department, and they worked together, and actually we did a test run on Monday, and it worked fine. And then creating the connection. They gave us Paul gave us some guidance on the speakerphone to use. Hopefully you're able to hear me and clearly. And but from my end, it went very well. It's not as not quite the same as being in person, but I appreciate the opportunity to do this. Yes, sir.
Okay. Division, how did this work for you?
I think it's about as close as you can get to being in person, so it was no objections on this side.
Paul, for your input, and just speaking for myself, I'll let the other board members speak, but I thought the microphone was as good as we've had. Any other board members want feedback on it? I tried to get them to tone it down. The only thing other thing I think we learned from this is, Mr. Biancardi, as you move papers around and other things, we could hear it on this end. So okay. I think the thing we'd recommend for future would be that until you're ready to speak, turn your mic off so we don't hear those background noises. But we didn't hear anyone in the hallway or anything else. We thought it was excellent. Okay. With that, I think we're out of here. Thank you all. Appreciate you.